of the appeals court. Now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the appeals court. I am Justice Rubin. I'm joined by two excellent colleagues today. To my right, Justice Desmond. To my left, Justice Singh. We will be hearing 6 cases this morning. And to give you a heads up, we will take our traditional mid-morning break after the first 3. The rules of argument here are familiar to those of you who have argued here before. They are 15 minutes aside, and there is no rebuttal. As you've heard from one or another of us before, perhaps, we've read your briefs and are very familiar with the facts of the cases, so you may want to just get into your argument. Having said that, it is your time, and you may do with it as you wish. The first case we will hear this morning is number 23-366. This is a partially impounded case, I am told. I don't know the scope of the impoundment. I'm assuming you both do. Are we saying the name of the defendant here, or is that impounded?
I believe the name of the defendant's been published. I don't think that's part
Okay. So this is 23-366, Commonwealth versus Rathbun. And I believe we will hear first from Attorney Keneally.
Thank you, Your Honor. May it please the Court, Joseph Keneally for Mr. Rathbun. The first issue before this Court involves whether the evidence was legally sufficient to prove that Mr. Rathbun was sexually dangerous.
Can you move the mic a little closer to yourself?
Certainly. Is that better?
Yeah, I think.
Okay. Specifically, it's the defendant's position that the evidence was insufficient as a matter of law to prove that he has a personality disorder as defined by the statute. Now, at the outset, Your Honors, I would suggest that these sufficiency claims are raised all the time and very rarely prevail, and that's because you usually get a qualified examiner who will testify the defendant was convicted of sex offenses. He currently has a condition that renders him unable to control his sexual impulses, and as a result, he'd be likely to reoffend if released. They generally support their this conclusion with observations, research, clinical assessment, and provide the jury with evidence to support those conclusions that will generally survive a directed verdict. In this case, I would suggest it is different, because here, both qualified examiners testified that, in their opinion, Mr. Rathbun was able to control his sexual impulses at the time. Specifically, Dr. Bell testified he saw no evidence that Mr. Rathbun was unable to control his sexual impulses over the past 6 years.
Did he conclude that he had a personality disorder?
What happened was both qualified examiners stated that in their conclusion that the defendant had a personality disorder as defined by the statute. However,
That's a yes, right? That's a yes. He concluded that he had a personality disorder.
he testified that that was his conclusion. I would submit, though, that simply stating that that is your conclusion is insufficient to support the claim, because a personality disorder, as defined by the statute, is a general lack of power to control sexual impulses. Now, obviously, that doesn't mean that you have no power, but the courts have held, and the SGC held in the Butiu case, and obviously the Supreme Court in Kansas versus Hendricks both said that the issue, the impulse control, it has to be difficult, if not impossible, for an individual to control their sexual impulses. And here, when you have both experts saying, in our opinion, Mr. Rathbun is currently able to control his sexual impulses, you cannot reach the determination that an individual has a personality disorder. And what you have left here is testimony as to a conclusion, absent evidence to support that conclusion, evidence to the contrary. A jury, when they hear expert witness testimony, they're not just given a conclusion. Otherwise, a qualified examiner could just step up and say, yeah, I think he's sexually dangerous. No, no.
Well, let me just step back. Was the testimony that the defendant was able to control his impulses, or was it that there was no evidence in the recent few years that he's not able to?
Well, there was evidence that from 2015, the time of his last offense, until 2018, he had spent 2+ years in the community without offending. There's evidence that, during the course of his incarceration, he also did not offend.
But the testimony was more to the effect that there was no evidence that during that time frame he was unable to control his impulses.
Yes, and I
That's not the same thing as an opinion that he is able to control his.
Well, I suppose that's true, Justice Singh, but this goes back, I would submit, to the burden of proof. The government has to prove that he is currently unable to control his sexual impulses. And if the testimony is, for the past 8-10 years, there's no demonstration that he's unable to control them, I don't think that testimony lends itself to proof beyond a reasonable doubt that, in fact, Mr. Rathbun is unable to control his sexual impulses and, as a result, has a personality disorder.
Can the fact finder take into consideration any efforts to remediate his problem? For example, if at a certain point in time, there's a determination that he's not able to control his impulses, if there's nothing done after that, meaning no treatment or nothing to indicate that the problem has been resolved, does that allow an inference that that condition remains?
I don't believe so. I think that what you have to look at is, to some extent, what they attached the mental condition to. And in this instance, they said that he suffered from antisocial personality disorder. And obviously, antisocial personality disorder by itself, the George case and the RB case say that's not sufficient to render someone sexually dangerous. But when they looked at that, there's no indication that he was even behaving in a way that would indicate he was currently suffering through it. I mean, in 3 years, the infractions that they listed as indicative of his inability to control himself and to abide by the rules was he had an alcohol-related incident. He missed a doctor's appointment in 2019, and he was found with a messy room. I think when you have a situation here where there's no indication that this man is in a condition where he is even slightly inclined to offend, then I don't see how you can take from that, particularly when you consider the expert witnesses saying we have no evidence here that he can't control himself, that from that an implication can be made or an inference can be made that in fact he's unable to control himself. I think this might have been a significantly different case if this testimony wasn't here, and you say that a lot. But now, I mean, to find a personality disorder, it isn't just can he control himself, or is he struggling to control himself? The due process requires that it be difficult, if not impossible, for him to control himself. And when you have two experts, the two experts who are required to reach this conclusion, they say, we see no evidence he can't control his sexual impulses. And on top of that, in spite of that, they say, well, he has a personality disorder. What you have now is like statutory incantation of the language in order to get you over the hump. You cannot just say, I'm concluding he has a personality disorder, and that's it. You have to have evidence to back it up. When the judge instructed the jury, he said that they're required not to simply listen to the conclusion, but look at the evidence that the experts relied upon to reach that conclusion, and assess whether you believe it, whether they reviewed it appropriately, and how they took it, and how whether or not the conclusions reached matched the evidence that it was allegedly based on.
Sure. And we assume that the jury followed those instructions, right?
Well, I mean, I would think, obviously, my argument here, Justice Desmond, is that there should not have gotten to the jury simply because...
I understand, but
yeah.
you just pointed out what the jury instruction was, and we assume that the jurors followed that instruction.
Well, my position is that the jurors could not have followed that instruction because there's absolutely no evidence upon which they could base it. All you have here is the conclusion.
What do you say to Dr. Peretti?
Pardon me?
Dr. Peretti testified in this case? Is that
She
right?
did.
And what do you say to her testimony?
Well, Dr. Peretti testified that since 2015, both in the community and in the prison setting, Mr. Rathbun has been able to control his sexual impulses. That's at page 678 of the record appendix.
Did she conclude, however, that he was likely to reoffend?
Yes, but
Page 672?
yes, she did, and so did Dr. Bell. But I would submit that these are two different elements, and they're distinct in a fundamental way. Because I could be in a facility, and I can tell a qualified examiner, the first thing I'm going to do when I get out is sexually reoffend. And that would make me wildly likely to reoffend. But that doesn't mean that it's an impulse control problem. It means that I might be in it means that I plan to do this, but not that I can't control myself. And Kansas versus Hendricks says the issue here, the reason why we're at a treatment center here rather than a prison, a corrections facility, is because the individual, it's not a matter of is he going to do it, is he likely to do it, it's like can he help himself? And if you don't have he can't help himself, you don't have a personality disorder. And that's what distinguishes this from regular criminal behavior. So, the notion that someone is likely to reoffend, while certainly an element of the offense and something that has to be proven beyond a reasonable doubt, is not exactly related.
In the record appendix at 415, Dr. Bell says, I think that not only speaks clinically to his antisocial personality disorder, but also to his inability to control his sexual impulses while he's been in the community.
Yes.
Now, I understand that you posit that an absence of sexual offenses in prison or while incarcerated demonstrates that now he can control his impulses. Is there a case that says that?
A case that says that the absence...
A case that says that when the person is coming out of incarceration, the fact that they haven't violated the rules of the place where they've been incarcerated by committing sexual offenses demonstrates or can be used to demonstrate current ability to control their impulses.
Well, I mean, there's case law that suggests, and I don't have any off the top of my head, that suggests that if you are acting out sexually during...
Of course. I'm asking about the opposite.
Right. Off the top of my head, I do not know if there's a case law out there that says specifically the fact that you haven't offended in prison demonstrates that you do not have a sexual impulse.
That's what you're asking us to do, because we have a statement in terms of sufficiency. We have Dr. Bell saying he hasn't been able to control his impulses in the community.
Well, respectfully, Your Honor, I think that quote, he said that between the years of 2002 and 2015, he offended against 3 individuals. And then he said, so again, I also think that speaks to his inability to control his impulses while he's been in the community. It doesn't say while he is in the community, it says while he's been in the community. And
has he been in the community since 2015?
Yes, between 2015 and 2018, he was in the community for 2+ years, and he did not offend. I think the portion that you're pointing at here, Your Honor, specifically speaks to Dr. Bell testifying as to Mr. Rathbun's condition between 2002 and 2015, and not currently, because when he was asked about...
You keep saying currently.
Yes.
All we know about currently is, while incarcerated, he committed no sex offenses. And I guess, let me be more clear about this, I don't really see how that has anything to do with his ability to control his sexual impulses. He's incarcerated. Yeah. There are guards, there are bars, there are locks, and lots of things. You will be caught, and lots of things will happen to you. It's not like probation or parole. It's a pervasively controlled environment. So to say, it seems to me that if a person's been incarcerated, I don't know how you're supposed to show, obviously you could show completion of sex offender treatment and things like this.
Well, sex offending happens in incarcerated settings all the time. That's not disputed. People in the treatment...
Yeah, but it's not like if they changed the rule. Yes, people break rules. We don't like that. There's punishments for that. We hope everyone in prison adheres to the rules. And there's lots of things there to make them do so, and lots of negative consequences for not doing so. And unless you can tell me that every single person violate, and maybe not every, that almost all sex offenders violate the rules and commit sex offenses while in prison. I just don't know how much we can glean from following the rules.
I'm not saying that the fact that he hasn't offended in prison means that there's no evidence of a personality disorder. First,
No, I'm asking about ability to control his impulses. We all agree there's evidence of personality disorder.
well, there's evidence of antisocial personality disorder, and I would submit that that disorder is actually, there's a good argument it's in remission, because if you have antisocial personality disorder, it doesn't matter if you're in prison, on a basketball court, in the courtroom, anywhere else, you cannot abide by the rules. Okay, so the fact that he's in prison, if he has antisocial personality disorder, he's still going to be acting out generally. Okay, this is about an inability.
Now you're telling me things that aren't in the record. I have no idea what percentage of people with antisocial personality disorder, which if I had to guess, I'd say the prisons have a lot of, what percentage of them also violate the rules while incarcerated. There's nothing about that here. Now, if you're saying that what has to be proven here is that while in prison, the person continued to be unable to control their sexual impulses, I asked you, you don't have a case for that.
I don't believe that there is a case that says if you don't offend in prison, then you're automatically not sexually dangerous.
Do you know a case that counts? Oh, they didn't offend in prison. It says like, well, that's some evidence of ability to control their impulses.
Well, that evidence is used all the time in these in sexually dangerous cases.
Give a case for it.
I do not have a case that says if you did not offend in prison, then that means you're not sexually dangerous. I don't believe
Didn't
that.
say means, can be used as evidence of lack of ability to control one's sexual impulses.
Well, what I'm saying is the fact that these doctors looked at Mr. Rathbun for the past 8 years, realized that there's nothing that he's done. Now, in an incarcerated setting, sexually offending happens all the time. They're saying there's nothing here to indicate he can currently control his sexual impulses. And
In a pervasively controlled environment.
well, I mean, it's worth noting that the people that Mr. Rathbun offended against was vulnerable peer-aged men. Now, in those circumstances,
So he would have been so tempted that he'd violate the rules if only he couldn't. I mean, I don't know.
If he couldn't control himself, I would submit that that's probably what would have happened.
I think we understand the argument. Let me ask you this question. You said it was in remission. Is there some record support for that?
There is, I believe Dr. Johnson testified that his antisocial personality disorder generally ebbs during the course as one gets older. And given his almost complete lack of committing any sort of antisocial acts during the course of his incarceration, even prior to that, that was indication that while at one point he might have been in the throes of antisocial personality disorder, she did not believe that was the case at this point.
You said that it was in remission. Is there any record support for that?
I believe it's in Dr. Johnson's testimony.
Thank you very much.
Thank you.
Excellent argument. We will hear next from Attorney Burbine, I think. Yes.
May it please the Court, Carolyn Burbine for the Commonwealth. It's our position that the judge properly denied the defendant's motions for required finding in this case. Viewing the evidence in the light most favorable to the Commonwealth, which is the standard, we had 3 experts. 2 were qualified examiners. 1 was the Commonwealth's expert. All 3 testified that he has an antisocial personality disorder, and all 3 opined that he's likely to commit future sexual offenses if released into the community. And I think that's the key, if released into the community. And they all talked about how it was significant to them that the 2015 conviction took place after the 2010 conviction when he was incarcerated. They noted similarities among the 2015, 2010, and 2002 incidents. They all involved vulnerable people. One was an 80-year-old man who was bedridden, and the other 2 victims were asleep. All 3 resisted, yet he persisted. They also noted the significance that he still denies that he committed the crimes in 2015 and 2010, and that while he did acknowledge the 2002 offense, He minimized his responsibility, said he thought the victim sent signals, and emphasized that he was drunk. So, and all of them are emphasized that he has some participation in sex offender treatment, but they're not sure how long, and that is an important consideration.
With respect to his impulsivity, what do you say to your brother's argument, the counsel's argument, that his lack of offending while incarcerated is suggestive of his ability to control his impulses?
Well, I'm not aware of a case that says that that's a requirement before you can find someone sexually dangerous, that they have to have committed some kind of offense in the treatment center in order to counter or nullify all of this expert testimony about the significance of his antisocial personality disorder coupled with his lack of sex offender treatment, his inability to even admit that he committed these crimes. One of the doctors said that in the interviews, he couldn't see the patterns in his offenses. He couldn't identify why he does offend. She said he had no skills to manage his behavior or his risk in the community. And all of these, are factors in recidivism and whether he can control his impulses. And then they all did their static 99 scores and gave the results of those. And the judge had the opportunity to consider this evidence in light most favorable to the Commonwealth, and he did. And he denied the motion for required finding, and it's the Commonwealth's position that he was correct.
So, counsel, you're saying that even if there's no manifestation of an inability to control himself, in the absence of any manifestation of that in a 10-year period of time, you're saying experts could still opine that person has an inability to control themselves?
Do you mean manifestation in an actual offense? Or, because it's more than just impulse control, the way I understand it, it's reckless disregard for self and others. That's not necessarily that you're going to, commit an offense to demonstrate that. It's a lack of remorse. All of these things were demonstrated, and I think when you couple all of that with his inability to even admit he did these crimes, how can you put him out in the community when he has no ability to even reflect or understand what he did and that it was wrong, and yet he's supposed to control himself and hold it all together when he's homeless, and we just throw him. He plans to be homeless, and he even says he'll go to treatment, but he doesn't think he needs it. So I think that's all very telling about his inability to even admit that he has an issue.
One of the offenses, he was actually the caretaker for the 80-year-old victim.
Yes, Your Honor, he was the caretaker, and there was testimony from, I'm sorry, I can't remember which expert it was, that he had actually said to the victim, he talked to him about Gacy and Dahmer and serial killers, and then sometimes he withheld food, and sometimes he didn't take him to doctor's appointments, and the victim felt threatened by that. So, and in the other instances, he victimized people. One man was asleep and had taken sleeping aids and had consumed alcohol, and he took advantage of him, and then when that man pushed him away, said, knock it off, he came back again and did it. And in the oldest incident, again, it was someone who was asleep that he took advantage of. And one of the witnesses, I think it was actually Mr. Canavan, who offers support to people who have been released. He acknowledged homeless people are vulnerable, and he's going to be living in a homeless shelter. They also have substance abuse issues. There's also discussion, too, that he told one of the experts that he will abstain from alcohol use, but he wouldn't make the same guarantee about marijuana. So we also have substance abuse history and issues, and I just believe, taken as a whole in light most favorable to the Commonwealth, the judge's decision was correct. Did the court have any further questions?
Do you agree that under the statute, it is necessary before someone can be found sexually dangerous, that they have to have a personality disorder that causes a general inability to control sexual impulses?
I'm sorry, I don't know the source of that. I understand
It's
it.
the statute.
Yeah, I'm sorry.
I may be wrong.
Yeah, if that's,
but you
if
correct
that's
me
the
if I'm
wording,
wrong.
if that's the wording of the statute, yes, I'm sorry, I didn't memorize the wording of the statute. Yes, I agree.
Okay. So I want to just get back briefly to the control of his sexual impulses. I'll turn this into a hypothetical, but it might be almost this case. Someone can't control their sexual impulses in the community. They're arrested a bunch of times for sex offenses, and finally they're incarcerated for 20 years. While they're incarcerated, they don't commit any sex offenses. They're incarcerated. I mean, some people, obviously, we see lots where rules are broken, but I assume there are prisoners who don't break all the rules, partly because the consequences are pretty crummy. So, or maybe they don't want to. I have no idea. 20 years pass, and now the person's about to be released, and the question is, should they be committed as a sexually dangerous person? Is it sufficient to show that the last time they were in the community, the last day they were in the community, because of their personality disorder, they couldn't control their sexual impulses? Or do you have to prove that now, 20 years later, they still can't? And how would you prove that?
I think it's, I mean, you have your interviews, you have your experts. You know, the question is, as a result of that personality disorder, is he likely to commit?
No, it's personality disorder that causes a general inability to control his sexual impulses.
But
then if he has that, the question is likely, and I'm talking about this threshold question, is does his personality cause a general inability? And I'm just asking how you prove that when the person has been in jail for, not in this case 20 years, but let's take a 20-year.
Well, I think you have to do what the experts did here and interview him and see, does he understand, you know, does he admit that he committed the offenses? Does he understand?
That doesn't mean that his personality disorder, I agree, he may be remorseless, he may be untreated, he may be denying the offense, but he has to have a personality disorder that affects his general ability to control his sexual impulses. And I'm just having a hard time figuring out. Now, maybe the answer is, well, all we've got for a guy like this is when he was in the community. It's his fault. He hasn't been in the community for 20 years, but we look at what it was, and that's good enough. Or maybe we say, well, it's 20 years later. Who knows? It hasn't been proven adequately, and not lock him up as an SDP. And I don't.
Well, I think that's why we rely so heavily on the experts, Your Honor. And, you know, I think it would depend on how those interviews go and what his
But there's no, maybe I'm mistaken. You know, I haven't been all the way through all of the record. I mean, I've looked at the places I've been pointed to in the briefs, but I haven't been all the way through it. It doesn't seem that any of them said he can't control his sexual impulses now because of the personality disorder, except maybe Dr. Bell with that statement about, you know, that in the community he's shown he can't. Is that the question?
I think they all came up with, you know, some kind of language similar to that, and I think that is what it is. I mean, otherwise, I would imagine there would be a case that would say that you have to have shown something, have done something in the prison.
Do you have a case
setting
that says that if someone's been incarcerated for a bunch of time, that doesn't figure into this calculus? That you know what I mean? I mean, obviously it figures in the sense that if the person commits a bunch of sex crimes while incarcerated, then we can that's obviously strong evidence that they continue to be unable to control their sexual impulses. But do you have a case that says, look, what we're really assessing isn't can they control themselves in prison, even though that's the only place they've been for a long time. What we're really saying is, at the time they went into prison, which is the last data we have about the community, I mean, are there cases that talk about this?
I can't think of one, Your Honor.
They talk about the dynamic risk factors, correct? Do you know what the dynamic risk factors are?
Yes, they do. They talk about the dynamic ones, they talk about the static ones.
Right. And so can you tell us a little bit about what the dynamic risk factors are?
The dynamic ones,
Are those the risk factors that are
Those are-
susceptible to change over time?
dynamic ones are susceptible to change, and I think they all found that he had not demonstrated those. I'm sorry, I don't have the exact comments by them on that handy. But I think that they talked about, again, his lack of reflection, his inability to understand, to even admit that he had done what he did. All those factors that would point that there was some insight or some understanding or some ability to recognize he even has a problem, let alone control it or do anything like that. And they did, actually, I think age in the in some of the experts were talking, the defendant's experts were talking about his age and how usually such issues decline. But one of the experts, at least one, maybe two, said he actually has escalated as he has aged, that his initial crime was in his 40s, and he's actually had two in his 50s. And they consider that to be a factor, that he's actually not declining, he's actually escalating. But I'm sorry, I can't remember exactly what the dynamic testimony was from each one. It isn't, I do have it in my brief. I did separate it out in my brief, if that's of assistance to the court. Did the court have any further questions?
I see no further questions. Very good argument, very helpful to us. Thank you very much.
Thank you.
The case is submitted. The next case we will hear is number 23-1126. This is Department of Children and Families versus Mother. This is an impounded case, so I remind counsel not to use the names of the parties. You can refer to them as, for example, mother, father, child, and so on. And we will hear first from Attorney Lowe.
Thank you very much. Good morning, Justice Rubin, Justice Singh, Justice Desmond. May it please the court, my name is Lorna Lowe, and I represent the mother. Can I be heard, or would you like me to move the microphone closer?
Say that again.
I said, can I be heard, or would you like me to move the microphone closer?
Oh, I see. No, we can hear you, I think.
You answered my question. First of all, I would like to apologize. I made a mistake by not appending the full police record to my brief, and I was not made aware of that until I read Child's brief. As soon as I realized that, I contacted my brothers and profusely apologized. It was an inadvertent mistake, but I just wanted to let the court know that I am aware. Your Honors, we're asking the court today to vacate the judgment in order terminating mother's parental rights and remand the case back down to the trial court for further proceedings. The reason for that is that the collective evidence doesn't meet the standard of clear and convincing of current unfitness because it's rooted in stale evidence and at the time of trial did not reflect mother's current situation. If I could just take a step and paint a picture of this family, it's believe that it would offer useful context because the placement resource is actually maternal grandmother.
I wonder if you could just do it in the reverse order. Could you tell us what you believe is her present situation?
Absolutely, Judge. At the time of trial, this is not your typical case of a parent that is experiencing challenges. A parent, she did have some mental health challenges at the time of trial, Judge, but it's not the typical parent who sort of tries to get her act together on the eve of trial. This was, I'm sorry, I just lost your question. Did you say what her challenges were?
No, I'm saying
What her current situation was.
Right. What makes you think she's presently fit to care for this child who she's never cared for?
Well, in 2019, there was a foster care review panel that actually recommended reunification.
Sure. How old's the child now? 6?
He is 7. He will be 8 in about 3 weeks. And at the time, and one of the reasons that they had recommended that, and this was 3 years before trial, is that she had already was successfully engaged in her service plan. By the time of trial, she had completed her service plan and was still engaged in services. She maintained a home. She maintained employment. She was visiting with the children. She was proactively engaged in requesting visits, attending the visits, and she was attending visits, Judge, as often as grandmother would allow. Sometimes they were being monitored by the grandmother, sometimes they were being monitored by the department, sometimes both. Mother was asking that the children be allowed to play outside, to go to the children's museum, not be cooped up in the department, in the DCF office. And she was attending visits in a way that was meaningful, in a way that some of us who are parents may take for granted. She was doing what we might consider mundane, wanting to be there for their haircuts. She was also there for their milestones, wanting there to be there for their birthdays and for holidays, and very, very much wanted these children to see her as their mother, being a part of their family.
We're only speaking about one child now.
We're only speaking about one.
She has 3.
She
brothers are already with the maternal grandmother.
She has 3, and I'm glad you brought that up, Judge. Mother became pregnant with her first child, who is now going on 20, when she was just 15 years old. And so the 2 older children, who are now 20 and 17, they were 17 and about 12 at the time of trial. This was back in 2022. They were all under a guardianship, so they had gone through the probate system. There was never a C&P.
And were all raised by the grandmother?
They were all raised by the grandmother, but I would offer...
Presently doing well?
My understanding is that they're presently doing well. Mother is still involved, and she was involved with those children as well. This is a very tight-knit family. And the picture that I wanted to paint is that Mother was born in 1987, so she's 38 now. And she was raised really by 3 parents, by her father, her mother, and really the Northampton Police Department. And the reason that this is important is that the judge painstakingly points out in her findings, Mother's utilization of the police to settle disputes. But if we take a look back to the years of 2002 to 2005, between her mother and her father, really majority of her mother, they had contacted the Northampton Police Department over 22 times to help them parent Mother, and for disputes of varying degrees. Sometimes we concede Mother was either running away or threatening to run away, but they would also call if there was missing money. $85 was missing, a chain was missing. They thought Mother or the brother had stolen it. Mother wanted to sleep over at a friend's house, and she wouldn't listen to Mother, and so they wanted the police to come and tell her that she couldn't spend the night at a friend's house. And so these very petty incidences where the maternal grandmother would call the police to intervene helps to paint a picture as to why this mother included the police to settle even the smallest disputes, because by the time she was an adult, the police, quite frankly, were already a part of the family.
So presently, why is she fit?
Presently, she's fit, Judge, because she's continuing on to do what she had been doing at the time of trial. She has been continuing to engage in services.
You believe she's benefiting from those services?
She seems to be benefiting by those services because the proof seems to be in how she's continuing to maintain herself and sustain those same levels of employment.
Does she acknowledge that she has mental health issues?
She does acknowledge that she has mental health issues, and something that was really important that came out at trial is that she had a clinical expert testify to say that Mother was stable and had been stable since 2018.
I thought Mom testified that she wasn't bipolar.
I beg your pardon?
I thought mother testified that she wasn't bipolar.
She did, and I'm glad you brought that up because there has been some question. There's testimony that's in the record by Dr. Laney, who was the clinical expert. She was qualified as an expert at trial, who said that she wasn't sure that mother had bipolar. She also testified that mother's medication provider had not diagnosed her as bipolar, and mother's therapist has not diagnosed her as bipolar. She said that she's not ruling out bipolar, but she said that she also could not affirmatively say that she had bipolar. And so this is something that the judge did put in her findings as a mark against mother, but it's completely understandable because none of her providers are saying that she definitely has it. She does acknowledge that she has some mental health issues. Her medication was adjusted back in late 2018, I believe going on 2019, which helped to regulate her behaviors. That's something else that came out in the judge's findings. But it's unfair for it to be a mark against mother because this is something that her providers still haven't been able to definitively diagnose.
Could you address the issue that you raised regarding guardianship versus adoption?
Yes, I'm sorry. Which aspect, Judge, would you like me to address?
I think you make the argument that termination was unnecessary because guardianship was an available option.
Guardianship was very much on the table, and it's something that is really documented quite well throughout the record, throughout the transcript. I believe when parties arrived, the judge said, this is a guardianship. I'm summarizing, but I do have the language specifically in my brief that I pulled out. And at the time, grandmother was saying that she did want to adopt, but she was ready and willing to go along with guardianship if that's what the court ordered. Child had actually come in saying proactively that they were looking for guardianship. The department had held their position that they were looking for adoption, but the social worker that testified also said that guardianship would have been a reasonable outcome.
When is guardianship a preferable result? Under what circumstances is a guardianship preferable to an adoption?
I would say under these circumstances, Judge. I mean, certainly I would find that it would be quite confusing and particularly disruptive for this child and not the other two children to be adopted. All of the three children still live in grandmother's home. And so to single out Kenneth, I beg your pardon, to single out this child and for adoption seems to be extreme, and there doesn't seem to be any reasoning for it. Grandmother says that she was looking to adopt this child because she didn't want mother to bring her into the probate court system. Back and forth and have that disrupt him. However, she's not been litigious with this child whatsoever. She brings up the eldest child as an example. However, as I mentioned, that child was 20 and mother was engaged certainly in wanting that, in seeking the court's assistance in getting that child back. However, this child is 7 and she has not been litigious. Arguably, it's been the department that's been litigious in terms of intervening in this family, but mother certainly has not been.
So, the North Star for us is the best interest of the child.
I beg your pardon, Judge, I can't hear you.
I say the North Star for us is the best interest of the child. But let me ask you this question. Do you believe that the grandmother has the best interest of mother at heart?
I think that's debatable, and I think that the record really bears that out. There is, and I'm sure my brothers are going to bring this up, there was an incident that is disputed that happened in 2020 where mother argues that because of some noise that was going on in the household, aunt was working, and mother and her grandmother, not maternal grandmother, but great-grandmother, were speaking too loudly for her, and so she had gotten frustrated and needed mother to leave the home, and so mother ended up outside after she had just taken a shower and was partially dressed. And this is an incident that the grandmother is pointing to, and I would argue that this is her self-interested testimony because she wants to adopt this child, that grandmother points to as a signal of mother's poor mental health. And so
in that instance, didn't the police make some independent observations when they arrived on the scene?
They didn't, Judge, and I'm glad that you brought that up. The police arrived and then they left. and they did not make any report whatsoever. And so when the social worker ended up testifying to this incident and was asked on cross-examination where she got her evidence from, she had gotten it from grandmother. Grandmother had told her what happened. There was no independent evidence whatsoever. It was only, he said,
evidence that she was taken to a hospital?
yes. There was evidence that she had taken to a hospital, and actually mother also testified that she was taken to the
She
hospital.
said it was for a cut finger?
She said that it was a cut finger, but she also said that it was because she wanted it documented that this incident had happened. And this is something that mother has done, this is something that grandmother has done over time, is them wanting this documentation from independent sources. They want someone else to be able to say, this is what happened, because quite frankly, they don't trust one another. And so mother wanted to be taken to the hospital to say, this is not a psychotic episode. I'd like to point out that grandmother has sectioned mother before, way back when she was a teenager. She was not sectioned. She was not sectioned by grandmother, by the police, by anyone in the hospital.
Wait, so was her testimony that she was in the hospital for her finger? Or
yes.
to have it documented that she was not psychotic?
It was both, Judge. Mother only ended up spending about 5 hours in the hospital. She was seen there, and she was left with the bandage that she was hoping for.
So as we sit here today, does mother have mental health issues or not?
Mother does have mental health issues.
Didn't the police independently observe, one time they found her out in the street with the child who wasn't adequately dressed. I don't think mom was adequately dressed. It was 40 degrees out. She was ducking in and out of the doorways. She jumped on a school bus. That's pretty extreme, wouldn't you agree?
We would agree with that, Judge, and I would also point to...
Here was that.
That was 2017, and that was the incident. I believe the police actually filed the 51A. That was the incident that actually started the C&P. That was 2017. That was more than 2 years before mother had any sort of current diagnosis, and it was far in advance of her having her medication stabilized. But if we're able to look at mother today, she's nowhere near that person that she was in 2017, and I believe that that's something.
How recently have you spoken with her?
Within the last 2 weeks.
And so presently she's doing what?
Presently, she is doing well. She has actually been proactive in gaining a Section 8 voucher. I believe it's in the record that she was living in a studio apartment where she was paying full rent. She was able to get a Section 8 voucher for a one-bedroom apartment where she would be able to take care of. I would just like to point out that this is not your average case where this child, I mean, the judge seems to argue that
That this case is impounded.
I beg your pardon?
Part of this case is impounded, correct?
I believe the entire case is impounded since it's a CMP.
Just be careful not to use names.
I'm sorry, did I use a name?
The first name of the child.
I'm very sorry. I'm very sorry. That's not my intent. And I've lost my train of thought.
Presently she has a one-bedroom apartment.
Presently, she's got a one-bedroom apartment. There was an issue, I believe, that the court had brought up where they were concerned that mother wasn't going to be able to meet the child's academic needs if they moved from Northampton to Springfield or something. But I would point out that the child was in preschool, and so any change of school district is not something that would seriously impact him.
Way of transportation? I know she has a car. Does she have a license?
I do not know the answer to that question if she has a current license, but she is certainly resourceful and has been able to make each and every one of her visits, even though she and mother live in a different town. She's spoken with the school department in terms of busing and any other transportation that's available. I see my time is running low. I did want to address.
Actually, but yeah, go ahead.
It's up, I know. I did want to just sort of to point to the issue that I raised in Benjamin in my brief over the judge making the post-trial order on the motions in limine and how my brothers are going to point to Frank as being the controlling authority. We would look to Benjamin and say that we actually can't even get...
This is about the carry and how it can be used?
This is about the judge actually ruling on what criminal history she was actually able to rely on.
I read the ruling as saying that the carry would be used only for certain things. I don't remember two things, but not the details of the crimes, I guess.
There were two, Judge. I'm sorry I cut you off.
But there are Northampton and Holyoke police records with respect to which no ruling was made.
The ruling was made 4 months after the close of evidence.
No. The only issue raised before the judge was what to do with the carry. And the judge made, I think, oral ruling that the carry would only be used for limited purposes. If the material in the judge's findings is in the Holyoke and Northampton records, not taken from the carry, then what is the issue?
Respectfully, Judge, I disagree. There were two rulings. The judge made the ruling from the bench on the very first day of trial. Mother's counsel had filed motions in limine 6 months before trial. There was a pretrial conference. The judge still had not ruled. At trial, the judge had not ruled on her motions in limine. Mother revived that motion on the first day.
The motions about the carry or about all criminal events?
Both. So on the first day of trial, the judge made a bench ruling and said with respect to Mother's carry, she was only going to look at quaffs and convictions. However, and she said that she would take the motion in limine under advisement.
The motion in limine asked for what?
The motion in limine asked for that the Northampton police records be completely excluded, and in the alternative that there were certain incidents be excluded, and it also looked at the Holyoke police record saying that certain incidents be excluded. And so this is something that the judge did not rule on until 4 months after the close of evidence. That's why I'm bringing up Benjamin, and about 3 weeks before the judge issued her findings, and she substantially relied on those findings after the fact, and that's not allowable under Benjamin.
Okay, your time has expired. I think we understand your arguments.
Thank you very much.
Thank you very much. We will hear next from, well, first I gather that Child and DCF will be splitting their time equally.
Correct, correct, Your Honor.
And we will hear next from Attorney Cuttle.
Your Honor, can you hear me okay?
Yeah, great.
Good morning. William Cuttle for the Department of Children and Families. We're asking the court to affirm the trial court's decree terminating mother's rights and freeing the child for adoption with his maternal grandmother. I don't want to go through my arguments in my brief. You have my brief. I want to point out a couple of important factors, though, that I'd like you to keep in mind, which is the court in this case considered mother's long-standing history of mental health struggles. It's voluminous, the difficulty she went through. It's very sad to see, overwhelming at times from the time she was very young, with her first two children, through the birth of this child. But that was all before the court to consider, in addition to the evidence that was offered at trial by mother's own testimony. And I think this is very important, and I point this out in my brief, but I think it's important to mention here that mother's own testimony demonstrated her continued struggle with reality and her mental health issues. The court found that mother's view of the events in her life, from the sexual assaults earlier in her life, the incident where she lost the child the morning of March 18th, 2017, where she was appearing to be psychotic, walking around with the child. Mother has never acknowledged those incidents. Mother does not acknowledge her struggles as seen through the documentary evidence and the evidence offered by other witnesses, including maternal grandmother. Mother in her brief, I'm not sure of the proper word, but it appears to insinuate somehow that grandmother has an ulterior motive in caring for this child. There's no evidence to that effect at all. Quite contrary, the evidence shows that grandmother, thankfully, has been an important person in not only the three children's lives, but mother's life. She advocated for her own daughter for years, helping her to get to mental hospitals, trying to get her treatment, dealing with struggles at home with mother. She has been taking care of her other two children in guardianships, and this child was placed in her care when he was 6 months old and continues to be there. Judge Singh, your question about the difference between guardianship and adoption, if I could just add to that in this particular case, adoption is very important in this case because this child needs permanency. And in mother's argument, she says that mother has not been litigious during this period. the child's been in the department's custody. There's no opportunity to be litigious. Grandmother has been, and testified she was very concerned about mother interfering as she had done with her two younger children, and wanted to avoid that and just provide this child with a stable and permanent life. You know, as you can see in the court's findings and the evidence, the child's doing remarkably well. He's connected with not only his grandmother, but his brothers. He has access to his mother. Clearly, mother made strides during the case. The court found that she had participated in services. To her credit, she maintained an apartment. Her police involvement had decreased as time had gone on, although it was still present at the time of trial in terms of seeking the police to help her do certain things in her life. But the court found that even though she participated in some services, she didn't benefit from the services enough, or even close to enough, to ensure that mother could care for this child safely. And that's the ultimate conclusion that the court had to reach, and that's what the court did reach.
Can I ask you a couple of very specific questions about the record and the findings?
Yes.
Is there any evidence in the record that grandmother has experience in her job with assaultive individuals?
In her own testimony, Your Honor, which the court credited.
She says that in her job she has experience, not just that she has seen mother a lot and knows when she's,
I think it's in my brief, and I believe it is in the transcript. Grandmother testified that she worked at the hospital. She had to deal with difficult patients and has learned how to deal with people who have been aggressive. I believe that's what, in general, the testimony was.
And in terms of the Benjamin argument that mother makes,
Which
I
argument,
take
Your
it
Honor?
the Benjamin argument that mother makes,
Yes.
leaving to one side the Carey question and focusing on the Norfolk and Holyoke police records.
Yes.
She argues that the judge excluded anything from before mother became a parent,
Yes.
but then relies on certain incidents from 2002 and 2003 before mother became a parent. Do you know if that's right or?
Well, I'll answer your question directly. I think the court did rule on those motions to eliminate in, I think, June after the trial. The general motions were for staleness of the documents. The court admitted the police records 9 and 10 at trial, and there was no objection made by any party for their admission, just to be clear.
The post-trial ruling,
Huh?
I don't know if that's my microphone doing that, I'm sorry. The post-trial ruling,
Yes.
didn't it exclude anything before she became a parent?
Yes. Yes, it did.
But did the findings include things from before she was a parent?
I looked at, thank you for asking that question, because I looked at that this morning. I believe in the section, I don't know what page it's on because the findings weren't numbered, but in the section that talks about mother's police involvement, I think the first two entries are about 2002 and 2003. So the department would concede that if those are there, I think the first child was not born until 2004. Although I saw one instance in the record where the child may have been born in 2003. But regardless, I would concede that if there's any reference to 2002 or 2003, that should not have been there. But again, that given the volume of the activity is harmless. And the court had every right to consider the motions to eliminate at the time she did. She did that before she made her findings.
Okay.
Are there any other questions? If
I
not,
see
I'll-
none.
I'll be
Thank
happy
you very
to-
much. Excellent argument.
Thank you, Your Honor. I'll rely on the department's brief.
We will hear finally in this matter from Attorney Levin.
Good morning, and may it please the court. Charles Levin for the appellee child. I'm going to start perhaps going backwards by answering that last question. The motion in limine was denied except for records prior to mother becoming a parent. The exact date of that was June 16, 2004. That's the birth date of the oldest kid. There's actually only two incidents that the judge cites in the findings that are before that date. There's four ostensibly, but my brief points out, although a little bit in a different context, those two other dates are wrong. They're actually dates post the birthday. And we know that because they pertain to 51A reports about mother's parenting of this child. So it was obviously after the birthday while she was a parent. So there's really just two incidents out of a vast, I didn't even count them, a vast number of incidents that the judge cited, and it is harmless error.
So those are 2002 and 2003?
Yes. Now, all of that evidence from the Northampton Police Department records and the Holyoke Police Department records were in evidence. They were admitted at trial as Exhibits 9 and 10. I think the main problem with appellant's argument is they want to read that out of existence as if it just simply didn't occur, as if they weren't admitted. They were, and it plays a huge role in this case. It shows not that the court presented this bloated view, I think that was the word she used in her brief, of the case against mother and the police records against mother. The court went very much by the book, according to what those reports actually showed. And in terms of there being less evidence in the later years, the judge acknowledged that the evidence seemed to taper, but what's significant is that the tapering didn't indicate that the problems with mother's mental health simply went away. She was on schedule. She had the hospitalization in 2017. There were hospitalizations before that, but as of the care and protection filing, hospitalizations in 2017 in March, one around January of 2018, and then there was the incident in September 25, 2020, which appellant tells you that wasn't really a hospitalization. I don't think that's the issue. The point is that it was obviously a serious incident of her decompensation, which she still did not acknowledge, had to be taken to the hospital, was in fact released for it the next morning, but even up through trial, continued to maintain that she wasn't even at the hospital because of any mental health decompensation, which is just simply against the record. And if the record is, the part of the record that the judge credited was maternal grandmother's testimony. And she
Is that the only evidence about this 2020 incident?
I believe it is, Your Honor. I don't think that there's evidence, I believe, that she was at the hospital, as you had asked earlier.
But are there hospital records that were admitted?
No, not for that. No. So we do have grandmother's pointed testimony, detailed testimony. The judge credited it consistently. The judge discredited
Was it
mother.
hearsay from the aunt?
No. This was the grandmother was at the hospital.
No, about the incident itself.
Yeah, no, I don't think it was. I think the maternal grandmother was there. Maternal grandmother responded to the aunt's phone call, and
I see. Okay.
And appeared at the residence at the same time the police did. So, no, not hearsay. Mother claims the evidence is stale. It's not stale because it still has continuing vitality. As the case of adoption of Larry and progeny constantly remind us that so long as the protective concerns have not been resolved and there's evidence of a continuation, as there is a pattern here, Granted, it's not a pattern that now that it happens every month, but it does happen on a sort of a cycle, a periodic basis, 2017, 2018, 2020. That's significant. This would be a different case if mother walked into trial and testified, I had a significant decompensation. I was, I was out of sorts, and this happens to me, and now I've sought treatment for it. The treatment's been successful. I'm able to understand what happened and prevent it. But that didn't happen at trial. It was quite the contrary. Mother came up with excuses for each hospitalization, for each of the incidents the judge cited, all of which run contrary to the record. They run contrary to police reports. They run contrary to maternal grandmother. The judge consistently discredited her. And
Have you recently been in touch with your client?
Yes, I've seen my client within the past week and a half.
Is the child still placed with the grandmother?
Yes.
And the grandmother's intent is still to adopt?
Yes. Yes, and just to address that very briefly, that the impetus, I think, towards the end of trial for choosing adoption over guardianship was, in fact, that grandmother had attempted to disrupt the guardianships of the two older children. And it sounds almost cliche, but this child does need permanency. Child's been there basically all his life. He's ensconced there. He sees this as his family. He's very close to them, very attached to them. As for mother, he's okay with the visits, but he doesn't talk about mother in between visits. And, I think that the biggest, perhaps, thing you can say in favor of maternal grandmother here is her advocacy for her daughter, the mother, has been significant. It was because of that advocacy that the trial judge awarded this mother a visit a month. That's almost unheard of in our cases, 12 visits a year. And I see my time is running out, but those visits have been happening.
Counsel, just on the guardianship versus adoption issue again, it was pointed out that everybody came into this thinking we could continue with the guardianship, and then it shifted to adoption. Does the judge need to? Wouldn't it always be the case that the permanency of adoption would be preferred over guardianship? Does the judge have to do something, make any further findings?
Not always. I think this incident, it was significant that there was actually a history that was explained in court of mother being disruptive to the two other placements. I think it's significant too. The goal actually coming into trial was not guardianship. The goal was adoption. That had been set in April of 2018. So it was a long-standing goal. And I think that actually when they walked into court on the first day of trial in February 2022, that's what everybody was planning for. And then in the course of trial, I think, is when there was some discussion about perhaps that changing to a guardianship because mother was propounding it.
Thank you very much. Very helpful argument from all three of you. The case is submitted. The next matter we will hear is number 23939, Butiu versus Mantenna. I apologize if I've mispronounced either of those names. And we will hear only from Attorney Durland.
Justice Rubin, Desmond, and Singh, my name is Sandy Durland. Warner, Federico, and Ryan in Boston on behalf of the appellant wife, mother. Good morning. In this appeal from a judgment of divorce, the mother is seeking a reversal and remand in connection with the judgment, which flowed from how the judge addressed two discrete treatments of the evidence below. First was the time limitations that the judge imposed, which then led to an incomplete record when the husband, in this case, abruptly chose not to testify.
So let me just ask you a little bit about that. From reading the papers, it appeared that everybody was under the belief, or was led to believe, I don't know if they were led to believe or it was just simply under the belief, that husband was going to testify.
Right, correct.
And it sounds like Mother's Counsel may have made some strategic decisions with respect to the evidence under the presumption that husband was going to testify and didn't offer some evidence that they may have otherwise offered in their case in chief.
I think you're absolutely correct about that, Your Honor.
So was that just a strategic error on counsel?
Well, the record shows that at the beginning of the trial, when the judge, was assembling the parties and the exhibits and whatnot, she posed the question to mother's attorney, who said, "I presume the husband will testify." When asked, "Are you calling him?" And then throughout the case, I don't think the record really reveals sort of the chaotic nature of this trial.
But that presumption to begin with.
Well, yeah, right, but throughout the case, it was clear that both the judge and mother's counsel, more so the judge, I mean, there was discussion throughout mother's direct examination about him interjecting, pontificating, effectively a speaking objection in the nature of testimony, and the judge kept pushing back, saying, "You'll have your chance," and he kept acknowledging, in so many words, "I will have my chance." And then when
did he say that?
I'm sorry?
Did he say on the record, "I will have my chance,"
Well, no,
indicating that he was going to testify?
Well, he didn't use those words. That
Okay.
is a characterization on my part, Your Honor. But I think a fair reading of it, when the judge said, "You'll have your chance, this is not your turn," again, I'm paraphrasing, he said yes, or he acknowledged that admonishment and directive from the judge. I mean, it is his ultimate choice whether to testify or not. But in this setting, his decision not to testify then led to this incomplete record. Now, the wife's attorney tried to remedy this once this became clear. They came back from lunch. The judge,
Once it became clear, that's once he decided he wasn't going to testify.
Right. I mean, they came back from lunch. The judge abruptly said, "You have 5 minutes to mother to complete her case." That was out of the blue. That was not made clear any time sooner. But again, putting that aside, the judge took a very inflexible approach to this for reasons which really aren't apparent, particularly when it became clear that father was going to or husband was going to testify, and then mother's attorney attempted to then recall her client so that they could try and sort of fill in some of the gaps. And the judge even acknowledged, "I know," in so many words again, "I know what you're doing, but I'm not certain I'm going to give you that leeway." And she did use the word leeway. And again, it's not clear to me why, she was so unwilling to be flexible when just before the husband announced, "I'm not testifying," the judge said at about 2:40 in the afternoon, "You have 2 hours," meaning they're going to go to around 4:30. And at that point, he cross-examines the mother for a while, and at about 3:15 then says, "I'm done." So there was time.
At that point, mother had rested.
I'm sorry?
At that point, mother had rested, right?
She never rested per se. I mean,
She gave a closing.
well, she gave a closing because the judge directed her to give a closing.
She didn't insist, "I haven't rested, Judge."
And she gave the case over to the husband.
Well, that is true, but she then sought to remedy that.
I get it.
Well, let me ask you this. On the record we have,
Right.
let's start with what that looks like. Because you seem to be saying it's an incomplete record, and I get there are ways in which it is. I didn't see any evidence in this record indicating that supervised visitation with the father would be safe. Is there any?
Well, insofar as the statutes, Section 31A of Chapter 208 requires that the effects of abuse be addressed, there was no findings that made clear that any contact with dad would be beneficial to the children. The evidence did show that the abusive behavior had detrimental impacts on those children. So it was somewhat of a stretch for the judge to simply conclude that supervision would somehow be in the children's best interest without then saying that contact would have benefits. That was not, there was no evidence of that whatsoever. And that's one of the problems as well.
Well, I don't see why that's a problem for you. If the father failed to put on any evidence, I mean, I understand if you didn't put on enough, but if the father fails to put on any evidence of why a supervised visit was safe or a good idea, and there was evidence, I think, that was credited by the judge of all of this abuse, then it seems to me you have at least an argument that supervised visitation wasn't properly supported and there were no findings. And
that is my position.
yes, and that doesn't have anything to do with an insufficient record, right? I mean, even on what was put in, it seems like you have that argument.
Well, no, that's a good point, Your Honor. There's two problems here. First is the incomplete record, but that really speaks to more of the marital estate, which would have been embellished could have been embellished in a number of different ways that the judge was unwilling to entertain. With respect to the custody issues, that record is relatively clear that that the behavior had detrimental impact on the children. So I don't quarrel with the record in that respect, only the judge's conclusion, which I don't think flows from that evidence.
Counsel, could you speak to the property issue, the distribution of the property? In what way is the record incomplete?
Well, a couple of ways. First, there was evidence, there's two. The father had acknowledged both in earlier financial statements, although not a trial, that he had a retirement account. And at one point, a balance was even referenced. The mother testified to his ownership of real estate, both at the beach and agricultural in India. There was testimony about a safe deposit box, which the mother testified held valuables like gold and jewels. None of that was addressed whatsoever in the judgment, but the mother did allude to it in her testimony, again, assuming the father would then be challenged on that. He also acknowledged other aspects which the judge didn't make any findings on. Yeah, again,
but were there findings to be made? I mean, what was put on by the wife in terms
well,
of...
she testified. She is the one who testified to the real estate in India. And
right, but without sufficient detail to allow the judge to make any more detailed findings.
Well, she didn't make any findings. She didn't make any, she didn't even acknowledge that it existed.
Wait, doesn't the judge say they keep their respective property in India?
Well, in the judgment, but she doesn't make any findings per se about that. And
you mean about the value of each respective property, or about why they each get to keep their own, or?
Well, I mean, I think it's fair to say that the judge's division of the estate, such as it is, it was incomplete. I mean, again, the judge was not given an easy task here, but she did not explain sort of how she reached the division of whatever she wanted or whatever she could divide. I mean, she ordered a lump sum from the to the husband from the wife of $93,000 and change. It's not clear how that was even determined. I speculate in my brief as to how it was reached, but it's not clear whatsoever where that came from. And it's certainly clear, I mean, you can't deny the fact that the division heavily favored the wife. I mean, it was essentially a 2/3, 1/3 division of what the judge had both identified in the findings and evidence and added values. But these other things were not addressed in any meaningful way.
Indian property and the safe deposit box are the two things that you say were not addressed.
They were
in a
not
meaningful
addressed.
way.
Only in the most general sense. And his retirement is another example. The wife's attorney sought to inform the judge that there were records of some of these assets that they could introduce or attempt to introduce through the wife if he wasn't going to testify. And that's when the judge then turned to the husband and said, do you object to these records? And he said, I object on the grounds of relevance. And the judge then wouldn't accept them. Tacitly, I guess.
Wait, you attempted to introduce records of the retirement accounts, and that motion was denied.
At the beginning of the trial, the pretrial order in this case said all exhibits are to be pre-marked. The husband did not cooperate with that. He did not lodge an objection to the wife's proposed exhibits. They introduced those at the beginning of the trial to the judge, and she said, if he's objecting, I'm not accepting them. Later,
the judge said, I'm not accepting it as stipulated. You
Right.
have the burden of getting it in.
Right.
properly.
She wasn't going to accept that as an uncontested exhibit because he didn't agree.
I mean, I guess I don't fully understand this. Why would he put in evidence that he had more wealth in his case? Right? It's your burden. You can't even cross-examine. Maybe you cross-examine him if
I
he
don't
said
know if I agree with that, Your Honor. Both parties are bound by both the rules pertaining to financial statements and case law to be open and complete in terms of their disclosures. There's no question in this case that the judge just, flouted that and just, did whatever he wanted to do. And in effect, the judge gave him a pass for that. And that's the concern here, because ultimately, by virtue of his behavior, we don't know what he benefited from because of this incomplete record. And had the judge been willing to be more flexible, which I think she's required to do in sort of this circumstance, to allow the wife to return to the stand so that she could attempt to lay a foundation to introduce certain records, those records that initially were not uncontested, then the record could have been more robust. And then, again, in the post-judgment motions...
The record could have been more robust had Mom put in some of this evidence in her case in chief.
Well, I can't deny the fact that she...
So that was a discretionary call by the trial judge that reasonable minds may or may not agree with. I get that.
Fair. That's fair.
Let me ask you this. Father has an engineering degree?
I'm sorry, Your Honor.
Husband has an engineering degree. What's his degree in?
He's a software developer.
And at one point, he was making $137,000 a year.
Correct.
Got served with a restraining order. Is that right?
I'm sorry.
Got served with a restraining order? Did he get served with a restraining order?
He did, and then he stopped.
And then he quit his job.
Yeah.
And so the judge attributed zero income to him as a result?
Minimum wage.
Minimum wage.
But there's no evidence that that he quit due to incapacity to continue doing the job.
Well, I think
unless maybe smoking weed counts as incapacity, but I don't think
the record does not reveal why he's not working. Okay.
But the record did reveal the impact of his substance use on his mental faculties, right? Wasn't there quite a bit of testimony about how he reacted to these things?
Well, certainly, the record certainly reveals behaviors from his substance use which led to abuse. What, if any, impact it may have had on his employment is not in the record. But certainly, again, I'm starting to sound like Johnny One Note here. The reality is, had the judge allowed her mom to return to the stand, tax records, retirement account statements, that sort of thing could have been introduced into the record for purposes of both determining the marital estate and calculating support.
So at bottom, your position is, just as a matter of fundamental fairness, in
Yes.
light of the way that this trial specifically was conducted, but in large part because of father's or husband's conduct.
That's it, in a nutshell.
Got it.
I'll rely on my brief. If there's no further questions.
Thank you very much.
All right,
Very
thank-
interesting
thank
case,
you.
excellent argument.
All the best.
The case is submitted. We are going to take our mid-morning break, and we'll be back in about 15 minutes for the final 3 cases that we will hear today.
Hold on, rise, please. Court is now in recess.
cell phone, please make sure it's on silent.
Welcome back. We continue this morning's session with our next case, which, if I can get the documents in order, is number 23689. This, again, is partially impounded, and I'm not sure which aspects are, but I don't think its name is, so it is in the matter of Simpson. And we will hear first from Attorney Knudsen. Or Knudsen, I don't know if I'm pronouncing that right.
May it please the court, Jamie Knudsen on behalf of the estate of Wendy Simpson. Ms. Simpson was alive at the time of the trial, but she has since deceased actually while the appeal is pending. In the context of General Laws, Chapter 190B, Section 2-507, we are dealing with the question of whether John Simpson's will was revoked by revocatory act combined with intent. The judge made a number of errors of law as well as clearly erroneous findings of fact, and really ultimately down to the ultimate conclusion that the red markings on the original will, in her view, constituted highlighting as opposed to mutilation. It's clear that her ruling is an error of law because she bases the conclusion that it was highlighting, not based on anything that any witness said, that John Simpson sat with me and talked about this and he was highlighting, but merely on the fact that you could read through the letters, or read through the marking.
Not merely on that fact, and I'm not so sure it's clear that it's an error of law. That's what we're here to determine. But that being said, yes, she did conclude that she could read through the red highlighting, you want to call it highlighting or cross out, whatever you want to call it, but it was also the lack of the other things you'd expect to see. Signaled initials next to it, clear X's through it. It seems like it's only in certain portions of the will itself. And so, and then the other surrounding circumstances, which seemed fairly clear that he was not trying to leave any money for his sister.
And those are excellent points as to what she found. But what what this trial court ignored was the Worcester Bank and Trust Company versus Ellis, which is a very important case in this area and the most similar case. And I'll note
that's a pencil strike?
Yes.
Okay. I mean, I don't know what's a question of law and what's a question of fact here. Ultimately, there's a question of fact here, it seems to me. Well, intent is a question of fact, and that's here. So figuring out what was intended by this, I guess, is a fact question. But even if we treat it as a question of law, and I don't think that the judge was saying every time you can see through something, then it is not a cross out. This seems like an area of the law where bright lines are critically important. And if it were a legal question, mightn't someone say, yes, lining through something so that each letter has a line through it is crossing it out? We're not going to count something where you can still see the words. You want to cross out your will, ladies and gentlemen, you cross it out. You know, I mean, what would be wrong with that as a legal conclusion?
Well, number one, it's inconsistent with not just Worcester Bank and Trust versus Ellis, but also BAT versus Vitamin, a number of cases, that's not what's required. And it is true that that court, said, well, you also have to combine it with intent.
Of course you do.
And I want to take a brief digression to go back because one of the reasons why Judge Tierney in the probate court took exactly the approach that Justice Desmond took, which is, and I'm quoting from the volume 5 of the record appendix at 19, it's in the second paragraph. The court's decision state, or excuse me, I'm quoting, the decedent would not have revoked his will knowing that should he die intestate, his estate would pass to his sister he had specifically inherited. And so the problem with that is that...
That was one consideration, though, correct?
Absolutely, that's one consideration. But that is directly in contradiction to Ellis. Ellis is important to read on a number of fronts, but one of them is that one, because the court in that case discussed at great length that if they held this will to be revoked, that would be further away from what everybody knew about the intent of the testator than if they didn't acknowledge the revocation. So they basically said it makes sense and it would be closer, and if we hold that this is revoked by these little pencil lines through, then it'll be far from what he really intended. But that is the conclusion that was made. And that is exactly the problem here. And that's exactly the reason, and it's clear that Judge Tierney took that approach, and that colored everything she did, including her. So she cited Ellis. She cited Ellis for just the simple provision of the burden of proof. She cited Sanderson versus Norcross and Walter v. Walter. Those are the only cases she cited. Sanderson versus Norcross and Walter v. Walter are not on point. One, they were about obliteration, and they were about conditional revocation, where somebody makes some sort of mark and then writes some stuff on the side, not knowing that that's not effective.
Isn't
right?
this in some ways close to, analogous to conditional revocation?
No, absolutely not.
In terms of the evidence in the record about the decedent's intent to maybe get a new will, maybe make a revision.
Well, that's not the doctrine of conditional revocation or dependent relative revocation. That is where somebody marks through their will and then writes something else in, or they have some other concept that what they did was legally effective to give them a replacement provision in that will. That is not the case here. It's clear, and I do want to get to the fact that there is some very clear evidence of revocation regarding intent. Again, the red permanent marker.
Only that line. There's a couple other places where there's marker or crossed out.
Right.
So what would the will do if those provisions were removed from it? It would still have a provision that says I am deliberately not giving anything to my sister, I guess it is, right? And if there's no other heirs at law, would everything escheat to the state?
No, it results in intestacy, just as in Ellis. Ellis is exactly almost identical in this situation, where a number of lines struck through. There were some that they had not stricken through, but what the court held was
the signature page stricken through in that one?
No, and that's a very important distinction from the cases that Judge Tierney.
So I guess I'm still stuck on this. Isn't it a question of intent, and isn't there sufficient evidence to find either way?
Absolutely, Your Honor. In July of 2015, John Simpson wrote a letter to his attorney stating, destroy
Copies.
Yeah.
Destroy the copies.
Destroy the copies.
Destroy the copies.
And they were sent back.
So what does
And
that
yet
mean?
after he died, we found that he hadn't destroyed the copies or the original.
Right, but he had marked through the exact provisions that he indicated. And by the way, and this is where another place where that's so important is, so you're right. So Attorney Reed sent that back to him.
And he didn't destroy them. I'm just talking about sufficiency of the evidence each way. He didn't destroy them. He kept them, and he put these marks on them.
And then he asked for them, right, at the end of his life. He's asking, please get me that will.
Well,
The judge believed that.
So that my sister doesn't get it.
there is evidence that.
Of
that
course,
was true.
everybody might be lying, but the judge found that credible. We weren't there.
But when his attorney sent back, and this is why the copy, so Trial Exhibit 14 is also important to look at. And by the way, this is supported by the case law that that's in my brief.
What page is Ellis? You cite Ellis in your brief?
Yes.
What page?
Oh, well, again, it's important on a number of points. So, but pages 93, excuse me.
Brief?
I'm sorry, oh, of my brief?
Yeah.
Oh, it's throughout the brief. So yeah, Ellis is cited throughout the brief, which begins at page,
Is it listed in your table of authorities? Am I missing that?
yes,
Where is it in your table of authorities?
under W. So it's on page 31, 32, 33.
Oh, Worcester Bank and Trust v. Ellis, I see it now.
Oh, Worcester Bank. Okay.
Worcester Bank and
All
Trust
gotcha.
versus
I'm sorry, you
versus
refer to
Ellis.
it as Worcester Bank and Trust, then you refer to it as Ellis. You feel me?
But, so when Mr. Simpson, Mr. Simpson wrote the letter saying, not just destroy my will, but destroy my will, my healthcare proxy, and my power of attorney. He had a conversation
And
with...
he also said to, I guess, at least two people, I'd like to make out a new will.
Yes.
Okay, so now
different time.
we have a situation. Let's assume that that marking at least means I no longer give it to, I don't remember the name of the...
Teresa Fredette.
Yes, Ms. Fredette. I no longer want to give it to her. We were really close and now less, or whatever it is. That's not who I want to give this to. In fact, at some point he says, I'm not sure who to give it to, right? So he can revoke the will altogether, and that will result in Ms. Fredette not getting the estate. But if he dies before writing a new will, his sister, who he also doesn't want to get it, doesn't get it. So he has a choice. Should I destroy all of these? Or should I do something to revoke? Or should I just call my lawyer and say I want to make a new will, which he never ultimately did make a new will, but he called? How are we supposed to know? The trial judge heard the testimony, right? That's a fact question. Did he deliberately decide not to do this because it was more important to him that your client not get this than it was that Ms. Fredette not get it, right? Because we don't know. But those are sort of the two options, and of course, he wasn't a lawyer. I don't know what he understood about what is it, but in fact, those are the two options that you're positing. And I just don't see it. Maybe I'd have found the facts differently. I have no idea. I didn't hear the testimony, so it's hard for me to, I can't assess who seemed credible. But these marks, to me, they just don't necessarily, we'd have to find as a matter of law, red marker that you can read through revokes a will. And how can we say that as opposed to red marker might show when he brings it to the lawyer, he's going to show which is the parts he wants changed? Like, how would we know?
So red marker doesn't alone revoke a will, but combined with intent, it does. But the case law, including Ellis, is that if the will is found with these mark-throughs, right? And it is marked through, just like in Ellis, just like in other cases where
It was
there's...
used in Ellis.
Ellis was a pencil.
It was a
In
pencil.
1935. Did they have highlighters in 1935? Just asking.
Not that I know of. No.
So if you wanted to highlight something, you'd probably underline it, not cross it through.
Right, exactly.
Whereas this, you can read through.
Or, as indicated, and is in evidence, he had multiple, light green highlights.
I don't know that that's in evidence, and those pictures were taken, we don't know how far after these marks were made, and there's a million pieces of speculation involved in saying it was a Sharpie, and then the leap to, and a Sharpie means cross out, but a highlighter means highlighted.
Well, Your Honor, and I do want to finish the point on the copies. Okay, so the copies contain the blue permanent marker.
Why are the copies
and
relevant? You think they're relevant on intent?
They're relevant, and the cases say that they're relevant.
On intent?
On intent, yes. And the blue marker, and by the way, there's also some of it that's marked out with a line through it, not an underline. And then the healthcare proxy and especially the healthcare proxy, the blue marker is obviously not used for highlighting, and you can tell that by the way that it's on there.
That's the one where the signature is crossed out as well?
Yes.
Okay, well, so that piece of evidence cuts both ways. It suggests that he knew that if he really wanted to get rid of something, you cross out the signature, right? I mean,
that's not the holding of Ellis. I see that my time is up.
I've sort of. Okay. Thank you very much. It's a very interesting case and a good argument. Thank you. We will hear next from Attorney Carroll. I want to ask Attorney Carroll, just for our clerk's office record keeping, on behalf of what party or parties are you arguing today?
Your Honor, unfortunately, my co-counsel in the trial of this case was Michael Stone, who unfortunately passed away on August 15th. Fairly unexpectedly, as the record indicates. He was thoroughly looking forward to making this argument. So in order to have the appeal process go forward, I filed an appearance on behalf of David Reed in his capacity as the personal representative of the estate.
And so you're now counsel for both appellees?
That's correct, Your Honor.
But you're arguing on behalf of Reed as whatever, personal representative?
David Reed, the personal representative of the estate,
very good.
the name defendant in the case. And throughout this process, on behalf of Teresa Reed, whatever Attorney Stone was doing, rather than overwhelm the court, I generally joined in unless there was something, because I had consulted with him on that. I would say good morning, Your Honor, but it may be afternoon at this point.
It is not.
As I've indicated, my name is Attorney Stephen Carroll. I represent the estate, David Reed in his capacity as personal representative, and Teresa Fredette, the named beneficiary in the will. This case, as the court has just indicated, is a fact-driven case. The facts are fairly undisputed here. I would hazard to say they are undisputed, the facts that would determine the trial. In 2004, Mr. Simpson consulted with attorney David Reed about preparing an estate plan and was informed at that point in time, and the record indicates that if he died without a will, it would be intestate succession and his sister would inherit everything from his estate. This was something that Mr. Simpson did not want to occur. And he specifically took the action of preparing his estate plan and made a specific provision in his 6-page will, under its own article, Article 6, that specifically disinherited his sister from getting any benefits. And that's the relationship between brothers and sisters and mothers and fathers, etc. Everyone has the right to do that if they so choose. That was in 2004. From 2004 to 2015, the record and the facts, the record of the trial court and the facts indicate that everything was fine. In 2015, Mr. Simpson sent a letter to Attorney Reed, which specifically said, I'm asking you to destroy the copy of my will and other estate planning documents. A clear indication, Your Honors, that the testator understood the difference between a copy and an original. The original of which he had possession of since the day he signed it up till just days or weeks before he passed away, when he asked someone to secure it, to protect it for him. But I will touch on that later. In lieu of destroying a client's will without the client present, and in the letter you'll see that the testator asked for proof of destruction, the Attorney Reed contacted the testator, discussed the purpose of it, and was informed at that point in time that Mr. Simpson was considering changing the beneficiary of his will. Everyone has a right to do that. The copy of the will and documents were provided to him. And from 2015, he never followed up with Attorney Reed in 2015. From 2015 through 2019, there was no communication or indication from Mr. Simpson on what was happening. In January of 2019, Mr. Simpson, the trial record indicates, Mr. Simpson contacted Attorney Reed, again, discussing revising his will for the purpose of changing the beneficiary, but still undecided in that factor. So now we've got a will in 2004, a request for it to be possibly revised in 2015 that didn't occur, another contact from the testator in 2019 about the same issue, about changing the beneficiary. Within that same time frame, the testator contacts another attorney, out of the blue, the understanding is from a yellow page ad or somewhere, and has a discussion, and the record indicates, with attorney Jonathan Mayo. Attorney Mayo credibly testified that he spoke with the testator on 2 occasions. They were brief conversations, but the same discussion from the testator. I'm interested in changing the beneficiary of the will, but I don't know who it's going to be. He took no further action with Attorney Mayo. And the record reflects that those 2 conversations may have been on or about late November 2019, January 2020.
Let me ask you a question. I'm going to interrupt you for 1 second. I think we know the history, but in any event, is the fact that the judge determined that he did not intend to revoke the will, is that a conclusion of law or finding of fact?
That would be a question of fact.
So whether or not that's clearly erroneous is the standard?
Well, I'm sorry, Your Honor.
Whether or not that's clearly erroneous is our standard of review as to finding of fact, right?
That's absolutely correct, Your Honor.
Okay.
Can I ask you a question? If instead of red, whatever it was, this red ink that you could see through, if the testator had drawn a line through those words with a pen or a pencil, would this be a revocation?
It would not, in my opinion, be a revocation. It might be a stronger case to assert as a revocation.
But it's not as a legal matter. That by itself doesn't demonstrate revocation?
Not coupled without the intent to revoke at that point in time, Your Honor. So
one might cross out, I mean, I guess don't do this at home, kids, right? You shouldn't be messing around with your original will in some,
correct,
not sort of sanctioned by law way. But if someone picked up their original will and was like, but I don't want Therese to get this anymore, I want to change that. And so I'll bring this to my lawyer, they think, and they strike it through with a pen. It hasn't been revoked yet, maybe, if they don't have the intent to revoke it at the time they strike it through. Is that right?
I would suggest it is, Your Honor, because he, as you said, when he struck it through, or when he highlighted, or what his desire or intent was when he did that is a question of fact. And there is no, until he goes to his lawyer and makes that indication to his lawyer or to some other person, it's a question of fact of whether he wanted to do, whether that was a revocation, coupled with all of the other evidence that might come into trial, similar to this one. So it's clear the judge's finding that this was highlighting to draw someone's attention to the will makes sense because, as we've indicated, over the course of approximately 4 years, from 2015 to 2019, he was discussing possibly changing, I'll say, one provision of his will.
But that's the main feature of the will, right? So if you're saying, I want to change the main feature of the will, isn't that a revocation? In coupled with, I've crossed it out, I want to change the main feature of the will.
It's not the main feature of the will if you're the objecting party, Wendy Simpson, that's for sure. That main feature is that she gets nothing, and that's what the testator
Whether
was
it's the
desiring.
Jimmy Fund, whether it's Teresa Fredette, is of no moment. It still excludes her.
But if the, see, I also, is there such a thing as a partial revocation?
There would be, I would suggest there would be partial revocation if the intent of the party to do that was present. And there were other provisions which in the will that may have provided for the
Right,
partial
you can
revocation.
imagine a will that says, I want none of my estate to go to X, and then when the person dies, it turns out that X is the only heir at law. Is that the case here? There's only one heir at law? If Wendy had been, had predeceased the decedent and he was intestate, the estate would have escheated to the state.
I don't, Wendy was his sister, so whether there were heirs of her estate which would step in under an anti-lapse provision or intestate succession would have to be.
Although if she were excluded, then they wouldn't.
Well, but I was.
Oh, but if she had
you said
died, then
that
maybe,
it was
I see.
revoked. So now we're going in.
But if there were no, if she had no, I don't know what
Heirs
the
at
right
law.
word is, heirs or issue or whatever the right word is that we use for children or grandchildren or whatever, then it would escheat to the state. Will has no beneficiary but excludes the heir.
In all, I don't have the answer to that, Judge, but I would suggest it may well escheat to the state. But and that's not necessarily, that would not necessarily be against what the testator here would have desired if in fact that was the scenario.
So is this a partial revocation? We have an intent to want to change the devisee, and we have cross-out.
It's not a partial revocation because it didn't come to the position of a revocatory act. That was clear from the evidence. That was the clear ruling by the court.
There's a clear ruling by the court. The evidence seems ambiguous on the point at least. I mean, you may say it's not, but I have a bunch of copies of the will, or I have a copy of the will and an original of the will. I use one kind of pen on the copy, and you can't read through it. I use this red thing on the original. I mean, it seems, I mean...
I would suggest, Your Honor, it's because I know that I'm working on a copy here. I know this is a copy because I put in my letter to the attorney, send me the copy, destroy the copy of it.
Destroy.
I'm going to, in lieu of destroying it, I'm going to work it up. I'm going to see what I want to do with it. But I'm not changing my original will, which I have had since day one. And further, Your Honor, you know, after the testator was involved in a motor vehicle accident on February 2nd of 2020, which he subsequently died from in March, about a month later, during the term of his hospitalization, the record is clear, he had communication with his sister, Wendy. And based on that communication, he specifically requested that his will be retrieved from his home for safekeeping. There was a purpose to that. He understood that. He knew his will was there. He specifically requested Robert Fredette to go to the house, and Robert Fredette had known Mr. Simpson for a period of 20 years or more because of Mr. Simpson's relationship with his mother, to go to the house and secure the will because the sister had indicated he was concerned that Wendy might come to Massachusetts and destroy the will. That was done. And Mr. Fredette did not go there on his own. He went there with Joan Eisenberg. The record will indicate another completely disinterested person here who knew Mr. Simpson for a period of 20 years. It was that point in time that the original will was found, and the original will was secured after his demise. That's the will that was filed in court, the original will. The three highlighting markings are on the will when it was found. It's the Wendy Simpson, as the objecting party, had the burden to prove that not only was it a revocatory act, but when it was done, whenever it was done, there was the intent to revoke it. The objecting party failed to prove either one of those requirements for revocation of a will.
What do you say about your brother's argument that the judge got the burdens of proof wrong, that there's a rebuttable presumption?
That's not Massachusetts. That's not applicable in Massachusetts. There is no shifting of the burden to a rebuttable presumption. Massachusetts law is clear that an objecting party has the burden of proof. The evidence in this case clearly showed she didn't sustain that burden. There's nothing in the record to indicate, there's nothing in the testimony to indicate that Mr. Simpson ever said, I'm revoking my will. He ever said, I want someone else to be the beneficiary of this estate. He never said, I don't want Teresa Fredette to be a beneficiary. He simply said he was considering changing the beneficiary of the will. But he certainly, throughout the period in question, understood the significance of an original will and the significance of dying without a will. Based on the foregoing, Your Honors, I would request that the appellate relief sought by the objecting party be denied and the underlying judgment from the court be sustained.
Can I ask you two quick questions?
Certainly.
Am I remembering correctly that there was a safe that couldn't be opened?
There was.
Does the record show whether it was ever opened?
I don't recall offhand. I believe it was at some point open, but I know that no other will or estate planning documents were ever located.
And can I ask you a question outside the record?
I'm sorry?
Can I ask you a question outside the record?
Certainly.
Do you know if the decedent's body has ever been recovered?
I unfortunately do know the answer to that. It has not been recovered.
It has not been recovered.
It's still in the nursing home.
Okay. Thank you very much both. As I said before, it's a really interesting case, at least for me, but I'm a judge, so I think lots of things are interesting. And it is submitted. The next case is number 231189, Erickson versus Erickson. And I gather we will hear first from Attorney Entner. Is that correct?
That is correct, Your Honor. Good morning, Justice Desmond, Justice Rubin, and Justice Singh. My name is John Entner. I am arguing here today on behalf of the appellants, Bruce, Danielle, and Eva Erickson. Because everybody in this case is named Erickson, I'm going to be just using their first names for clarity purposes. We believe that the trial court judge made several erroneous findings of fact and clear errors of law that would permit this court to overturn the order and the judgment. And I could go down those findings and errors more specifically. We've briefed them extensively, but in full candor to the court, in thinking about this case and preparing for this argument, I've been drawn to an area where the trial court judge's order is silent, which is the time immediately following Doris's leaving Bruce's house. The trial court judge finds in 2007 or 8 that Doris moved out. The first evidence that we have that anybody came alongside Doris to help her manage her finances after that is when her daughter Gail is added to the bank account in around 2015. That's a 7 or 8 year period where Doris knew one of two things. She either knew that she had transferred the property or she believed that she still owned the property. If she understood that she had transferred it, she was totally fine with that. She made no effort at any point to claw back that property, to claim that Bruce had somehow overcome her will or her intent.
What were the circumstances when she left Bruce's house?
She left to move into a housing community called Turtle Woods, located on the North Shore. I don't know if it's an
for services as well as housing?
It offered it had services on call that were available for people if they needed it, but it wasn't a nursing home in the sense that people were assigned or always helping you.
Did she grocery shop for herself, or were her meals provided?
There is extensive testimony on the record from, I believe, all parties that she was driving at the time, that she was managing her own affairs, and we know she was managing her own finances because nobody else was added to the finances.
Grocery shop for herself, or were her meals provided, if you know?
I believe she was grocery shopping for herself, and I believe there's testimony in the record to that point. I know that she was grocery shopping for herself and cooking for herself during the period of time she was living with Bruce and his family, and I believe that continued while she was living at Turtle Woods. During that period of time, if she believed that she still owned the property, or if she knew that she had transferred the property, she made no effort to claw it back. A lot of the undue influence cases that I find when I'm researching undue influence in Massachusetts, it's situations where, removed from the domineering, overbearing influence of the undue influencer, those people then bring cases saying, I was put under duress and I transferred this property against my will. If she believed that she still owned the property, we have another void. She did nothing for 7 or 8 years to otherwise transfer that property. This isn't a case where there's another will or another writing or an alternative deed. This isn't a case afterwards where she made manifest her intent to leave this property to anyone at all, let alone Wendy. And I think that that void of information and that void of findings, and Doris clearly resting on what either had happened or on nothing at all, says that she didn't clearly intend to leave it to Wendy after Wendy's accident in 2004, after the statements after she transferred it in 2006.
Well, in her view, she might have already thought it was Wendy's, right? She had told Wendy that.
She was still
for you.
She considered Wendy to be a renter. She had a rental rider on her insurance for the property. And while that was her intent prior to 2004, and I disagree with those statements coming in under the deceased declarant exception to hearsay, I think that they shouldn't have come in at all. But to the extent that they come in before Wendy's accident in 2004 that greatly changed Wendy's circumstances. We have a lot of evidence on the record that Doris was transferring other real estate at that time. She was making inter vivos gifts to all members of her family, Wendy included, and at no point was she confused about any of those transactions.
So, I mean, a couple of issues. One, do we attach any significance that the trial judge really discredited much, if not all, of Bruce's testimony?
I do, Your Honor. I attach great significance to that. Case law that we cited in our brief states, and I quote, while a trial judge is permitted to reject all or any part of a witness's testimony, a wholesale rejection of unimpeached testimony may cast a pall on the findings, and importantly, disbelief of testimony does not warrant a finding that the opposite is true.
So I get it. It doesn't necessarily mean that the opposite was true.
Correct.
But nevertheless, the judge, for various reasons, discredited much of Bruce's testimony, including that he was watching him this was a Zoom trial, and was watching him, or what he perceived to be having conversations with somebody off screen, which Bruce denied. And so that was really the judge's own observations. So that being said, did Doris deed the property a month after moving into the house?
No, Doris had been living with them, I believe, since 2003 or 4 when she fell and injured her hip. Oh, no, actually, if I'm remembering correctly, I believe that they purchased the house in 2005, and at that point, Doris moved in with them.
When did they change the deed to the twins?
The deed to the twins was in 2006, Your Honor.
So shortly after she moved in with them?
Relatively shortly after she moved in with them. But even prior to that, in 2004, she was writing checks to Bruce, to Danielle, to Eva, in large sums for clear purposes. Her checks to Danielle and Eva in the memo line said College 529. She was familiar with the concept of a 529 plan and clearly intended inter vivos gifts to her granddaughters. So I don't believe that they're an unnatural disposition, if that's what Your Honor is getting at, simply because she transferred it to them. And as to your question regarding the judge discrediting Bruce's testimony, That's certainly within the power of the judge to do. He can discredit the testimony entirely. The problem that we have, Your Honor, is that on page, I believe it is 12 of the judge's findings, paragraph 50, oh, no, I apologize. In page 21 of the judge's order, he says, and I will quote it for Your Honor here, I do not credit any of Bruce's testimony that he had nothing to do with the 2006 deed and had no knowledge of it. Indeed, giving his false statements at trial, I find the opposite. He rests the finding that Bruce participated in the transaction on that discrediting of Bruce's testimony, which he clearly can't do under the case law that we have cited here for the court today.
But he can make inferences from the remaining evidence.
He can make inferences from the remaining evidence, but what he has in the remaining evidence, I don't believe, rises to the level of a solid foundation of established fact on which to rest the inference. He uses Bruce's participation to find that Bruce was sort of had a confidential relationship with Doris. And then in his order, he states clearly that a confidential relationship doesn't shift the burden to Bruce to affirmatively prove the validity of the transaction. But at other times in his order, he says there's no evidence that it was that Doris had a clear understanding of the impact on Wendy of the transfer of the house, or other elements of Doris's understanding that would have been Bruce's to put in to rebut a presumption or to carry a burden. So at the same time, while he's acknowledging it doesn't shift the burden, he's then taking the lack of meeting the burden as somehow proof of the opposite.
But there is evidence that she was susceptible to undue influence. There's evidence supporting the conclusion of unnatural disposition, even though you may disagree with it. I don't see why. And then the person who could have exercised undue influence comes in, lies. I discredit their testimony. I saw them lie in front of me. I'm looking at how the unnatural disposition works and how the, know that she was susceptible to undue influence and know that he was there, because there's affirmative evidence of all of that. And the conclusion I draw from that evidence is that he exercised the undue influence. I understand that his testimony doesn't prove the opposite, but his lying might be something that she can rely on.
It goes to another element of the silence of the trial court judge's order. He doesn't address any of the evidence or testimony from Ekaterina or any of the evidence from Eva. They also had different perspectives on the situation. Ekaterina especially, as she was the one tasked with paying the mortgage and the taxes and the insurance. So there's an absence of evidence here that forms the basis of the judge's decision, and we're left with the idea that the only evidence on the record was Bruce, who's a liar, and so therefore I can give more weight to these other elements of the evidentiary record.
Yeah, but well, okay, there is other evidence, and the question of whether it's sufficient we'll have to figure out, but it seems like there's evidence. What is this disposition? It's bizarre. Keep a life estate for herself when Wendy lives in the house, but will be kicked out immediately upon her death, even if she's still alive, and then it goes to 2 grandchildren? It's a little odd, right?
It's an unusual vehicle, but I don't think it's...
Well, vehicle for doing what? For kicking Wendy out when she dies.
It's an unusual vehicle if...
And even why wouldn't she have given a life estate to Wendy? And then when she dies, given it to... You see what I mean?
Unless she didn't have any intent to leave it to Wendy at that point. All of the statements regarding her intent to leave it to Wendy are before Wendy becomes a paraplegic.
Why did she keep a life estate? She doesn't live there.
She moved out into Turtle Woods a few years later. The only thing I can guess, and this is total conjecture, because again, we don't know her actual intent regarding this particular document, but she may have been foreseeing the idea that she may have to go live back there. Bruce and Ekaterina did move down to Florida. Wendy's house does have handicap accessible ramps and bathrooms. She may have been anticipating a future where she no longer could live at Turtle Woods and need to go there.
These are factual. We didn't hear the testimony, so.
And the fact is that there isn't any testimony about her intent to give it to Wendy until before. And even then, we think it's admitted as a deceased.
She didn't give it to Wendy.
She what?
She didn't give it to Wendy. It
Right.
passed to all three of the children. That's what it was always going to do.
Correct, Your Honor, which is another part of my issue with the judge's factual findings of the intent of Doris. If he's finding that Doris's intent or will for the property was overcome by this domineering, overbearing, undue influence, what was that intent? Because there were no positive steps taken to leave it to Wendy. As is, it is going to the three kids equally. As is, the judge couldn't find that it had ever intended to go to Wendy enough to actually give it to Wendy. All he could find was, I don't think she intended this, but I don't know what her intent was. And I think if you can't ascertain an intent that was overcome, then you can't claim that there was an intent that was overcome for the purposes of undue influence. And getting to the idea of the finances and other people having an opportunity to look back at Doris's finances even after she has moved out and been away from Bruce and his family for a prolonged period of time. Gail, in her capacity as a co-signer, never questions a transaction or looks through Doris's financial records and raises an objection. Wendy, who comes on as co-signer in 2015 until 2020, never looks back at it, never questions the transaction. Wendy has been paying a Katerina since 2006 for the property, and her testimony at trial was that she never questioned that. She never asked any questions about that. She just assumed that Katerina was helping Doris with her finances in some way, even after Wendy becomes the co-signer who's helping Doris with her finances later on. I think the judge was wrong to say that the statute of limitations doesn't apply, and wrong to be silent entirely in his order on the statute of limitations argument, particularly where the town of Danvers testified that the construction projects Wendy undertook on the property required permits, which would have required an owner signing on the permits and on the applications. I think there were numerous instances where Wendy would have had reason to look up the registry of deeds and see this publicly recorded, totally available document that would have indicated that Doris no longer owned the property before bringing her case.
Why would she do that?
She's required to get the signature of the owner before she pulls a permit.
Why wouldn't Bruce tell her?
Bruce doesn't have to tell her.
I didn't say he had to tell her. I'm saying, why wouldn't he tell her?
No one has an obligation to tell her anything. Importantly, Doris doesn't have an obligation to tell Wendy. Nobody has an obligation to tell Wendy.
I wasn't talking about his obligation. This is his sister, right?
Yes.
Okay, the house that she was living in had just been deeded to his children by their mom.
And you say, I mean, compared to she should go look in the registry, it seems much more likely
Bruce
that he would have told her. I mean, when my mother was alive, I never went to the registry once to see if she still owned her house.
I'm out of time. I would like to answer.
You can answer.
Bruce's testimony and Katerina's testimony and Wendy's testimony has all been that everything that happened with the house regarding the payments and the financials went through a Katerina.
So who else?
A Katerina. The judge is silent on a Katerina, but a Katerina was the person managing the payment of the insurance and the taxes, receiving the payments from Wendy for the house. Wendy at any point could have raised her hand and gone, hey, why am I paying you now instead of Doris? Why is the money for the house coming out of your pocket instead of Doris's financials? I think there's, as we cite to in West's case, person confronted with state effects, if they close their eyes in order they may not see that which should be visible and therefore known to them if they look, they're chargeable with knowledge of what they would have seen had they looked. I think there's plenty of instances where Wendy should have looked.
Where? In the registry?
Or asked a question. She never asked a question.
Okay. Your time has expired. Excellent argument. We will hear
Thank you very
now
much, Your Honors.
From, this is the kind of thing I should have at my fingertips, from Attorney Prettyman.
Good afternoon, Your Honors. May it please the Court, John Prettyman on behalf of Wendy Erickson. Justices, as you heard in the previous argument, this was a deed that was conveyed, that was signed back in 2006. For all objective purposes, multiple people if this deed had been done above board, should have known about this. All people related to Wendy Erickson, all people who you would think would tell a sibling or a sibling-in-law that the moment your mother passes, you're essentially going to be homeless, given her condition after her motorcycle accident as a quadriplegic. And all these people had testified that they were 100% silent.
Well, your colleague says when she died, Wendy was always going to be out of her house. It would have gone to the three of them. She'd have owned a third of it. I guess she could have, if they wanted to, bought out the other two. They could have brought a petition action if they didn't want to do that. You know what I mean? Somehow, right, the change is, does one brother's children own the house when she dies, or do, well, it's right, it's per capita, but essentially the three children of the decedent own it?
Well, you touched on it, and you're absolutely right. I mean, first of all, there's no way to know Doris's intent. So much has lapsed, so many memories have faded, so many documents that should be available do not exist. But assuming that this deed was just going to be in Doris's name and pass into her estate, Wendy would have gotten a third of that home, and which probably would have been a decent chunk of money for her to either try and buy out the other two siblings or their estates, or move into something smaller that's handicap accessible. In whatever way, use that money towards her future. You touched on this with your questions earlier. It kind of defies logic to just put her out on the street, say, well, it's not my problem after I pass away. A daughter that you've essentially cared for in one way or the other. I mean, this house was purchased, I believe, I forget the exact year, Your Honor, I believe it was in '85, but Wendy lived in this house at the time of the trial for over 35 years, I believe.
And Doris passed when?
In 2020.
Any home improvements made after that date?
After 2020?
Well, no, because...
Or after 2006?
After 2006.
Yes, Your Honor. Well, actually, that I would have to rely on my brief, or I could submit a 32L after argument. But right around the time of the conveyance is when Wendy had her accident. So the major improvements that happened after her accident were, I believe, the dining room was converted into like a bedroom. The bathroom was made handicap accessible. It's a two-story home, single family. Obviously, Wendy cannot get to the second floor, so the first floor had to be made essentially the entire unit for her purposes. So those happened, I apologize, I don't know the exact year, but right around the time of the 2000s.
Her accident was before the conveyance, though.
Sorry, I apologize.
Her accident was before the conveyance, alleged conveyance, or it was a conveyance, I guess.
So I know there was a time when she was in recovery. I know there was quite a bit of time. I do not know the exact year when the modifications were made.
No, I'm not asking about the modifications to the house.
Oh, yes.
I'm saying she had her accident and the conveyance came after that.
Correct.
So Doris would have known of the accident.
Correct.
Okay.
Yes. Yes, that is true. Your Honor, I also wanted to touch on, my brother talked about Judge Foster finding simply the opposite of what Bruce testified to. I don't think that's the case. I think there was extensive testimony. This was taken over a 5-day trial. There was testimony regarding a seemingly parallel transaction where Doris conveyed a condo that she was living in at the time to one of Bruce's other sons. And there was testimony from Bruce that he directly benefited from that conveyance in the form of, I believe, a mortgage was taken out on that condo. Bruce was paid, I think, approximately $40,000 to $45,000. I don't know the exact number offhand. And then ultimately that condo was conveyed back to Doris and she sold it. There's also testimony from Rob, another one of Bruce's children, that Bruce, during one of his birthday events where he was hanging out with his dad, Bruce came and asked him if he wanted Wendy's house put in his name. There was also testimony from Wendy. I apologize, Your Honor, I just lost my train of thought. Where I was going with this is there was extensive direct testimony from witnesses regarding these behaviors, not only involving the subject premises, but also involving in my opinion, near parallel transaction. And I think Judge Foster's facts, as he found them, support the conclusions of law that he came to. And there is one case, I apologize, Your Honor, I do not think it is cited in my brief, but I can submit it after this hearing. It's Markell v. Sidney B. Pfeiffer Foundation, Inc. The citation is 9 Mass App Court 412. It's a 1980 case. Whether or not a relationship of trust and confidence exists is a question of fact. That's the cite that I pulled from that case, Your Honor. And that is what Judge Foster found after this 5-day trial, that there was a confidential relationship between Bruce and Doris. He was very well educated. He had his Juris Doctor. He had worked in real estate before running a company that managed investments of others, and he had actually taken money from from Herman and Doris that was under management of his company, of which he was a principal. And Your Honors, unless there are any specific questions, I can rest on my brief.
I see none. Thank you very much.
Thank you.
Interesting case, and it is submitted. This brings us to our final case of the morning, which is also an impounded case. It is number 23-875, John Doe 114167 versus Sex Offender Registry Board. And we will hear first from Attorney Coase.
Thank you. Good afternoon, Your Honors. May it please the Court. My name is Matthew Coase, and I represent the appellant, John Doe. Mr. Doe committed his only sexual offense as a 16-year-old boy, and he spent nearly 2 decades in prison following that offense. His prison sentence was ultimately deemed unconstitutional because the juvenile court did not fully consider the attributes of youth during his sentencing. The hearing examiner's classification decision in this case suffers from that same problem.
And is that because we learned more about the brain development since he was incarcerated?
I believe that's precisely the point, Your Honor. I think there has been a significant revolution, if you will, regarding adolescent brain development in the science and the way that it's applied to the law. I think kind of more broadly, certainly Diachenko and Mattis and Perez, the recent decisions from the SJC. But I think it also applies with respect to sex offender classification in this particular context. And I would suggest that the hearing examiner had an obligation to kind of look at that science and science that was provided to him in the form of articles at the classification hearing. And
what year were those articles?
I believe the 2 articles that were presented were from 2016, which I believe those 2 articles were actually cited in SORB's regulations. There was an article that I had presented. I represented Mr. Doe at the classification hearing and in Superior Court. I discovered another article shortly after the hearing, which I presented to the Superior Court. I fully recognize that was not before the hearing examiner, but I do think it has some relevance.
Part of the reason that the hearing examiner gave little, I think no additional weight to those articles, those 2016 articles, was, I believe he said, because the regulations had already accounted for the differences between the juvenile and the adult offenders.
Thank you. I think you hit the nail on the head.
As cited, as you just
said. Right. So I believe that the regulations account for the differences between juveniles and adult males and the difference juveniles and females. But what it doesn't do is it doesn't count for that mitigating weight that should be applied to juvenile offenders. And if I could give the court just one example, and I'm kind of remiss for not making this point in my brief, but when you look at the regulations, 803 CMR 133, before the risk factors, there's kind of a introductory couple of paragraphs, and it talks about female offenders. And it says, the board recognizes that adult female sex offenders generally have lower recidivism rates than adult male sex offenders. The board shall apply mitigating weight to this lower recidivism rate along with the relevant regulatory factors in determining the final classification. So I would suggest kind of like that same type of mitigating weight should also be applied to juveniles, because we know from the juvenile science that juveniles generally have a lower recidivism rate and are more amenable to treatment.
Why do you think they say it with respect to women but not with respect to juveniles?
I just don't think it's been fully fleshed out in the law. I think, you know, the Supreme Judicial Court case in 205-614 kind of forced SORB's hand with respect to the female risk factors, but I don't think that that has been done in case of the juveniles. What I'm suggesting in this case is with respect to juveniles, kind of looking at it through that same lens, is the hearing examiner essentially did a tally sheet of the juvenile factors as opposed to the adult factors. He added up the risk aggravating factors and the risk mitigating factors and decided that the risk elevating factors outweighed the risk mitigating factors. What he should have done is done the analysis with the risk factors, but also a reasoned analysis, including the information about the juvenile brain research and its impact on sexual reoffense of juveniles. And I'd point the court's attention, I think there's a lot of similarities to the Doe 136652 case and the Doe 11204 case. In those cases, they're essentially what I consider the checklist cases, where this court has decided that instead of doing the reasoned analysis that it should, given all of the broad information available to the hearing examiner, they engaged in kind of a mechanical application of the regulatory factors. And again, as I mentioned before, I think that there was plenty of information in the record in order to make the finding that juveniles do have a lower risk of recidivism and are more amenable to treatment.
Do you also argue, maybe I'm misunderstanding your argument, do you also argue that the factors that the board uses don't take proper account of all the ways in which someone who comes in as a juvenile and is now an adult at the time of classification, all the ways in which that differs from someone who was an adult when they committed the crime?
Right, well, yeah, so I'm not making a direct attack on the SORB regulatory factors.
No, I understand you're not saying there's anything wrong with them, but that they are inadequate, that there needs to be other things considered.
Yeah, and I think that kind of leads me to my argument regarding the motion for expert funds.
Yeah.
Because I do think that these are very unique circumstances. We have an individual who is adjudicated as a youthful offender at the age of 16, spent a considerable amount of time in prison. You know, as I mentioned before, this was a prison sentence that was ultimately deemed unconstitutional. It violated Article 26. And so what you have here is a significant passage of time between the offense and when you're having the classification. You have an individual that matured in prison, went through the process of kind of aging out of some of these antisocial tendencies that he may or may not have had.
You have a number of disciplinary offenses, 50?
There were 50, Your Honor.
Right up till the end of his time in prison, virtually, no?
Yeah, I would agree that, you know, his incarceration was certainly a mixed bag. I think there's some evidence in the record that it improved over time. There was a renunciation of his gang affiliation. There was some involvement in programming. He got involved in education. And that was, taken into consideration as well.
One of the issues that he had at the time of the offense was his, I'm going to say chronic marijuana smoke, my word, not, I don't think in the briefs, but he talks about living with other family members and the kind of conduct he engaged in to make money at that time, and talks about he was high, I think, at the time he committed this offense. And wasn't some of his disciplinary offenses also stemming around substance abuse?
Absolutely. I mean, this is certainly a dysfunctional living situation that Mr. Doe found himself in. And, truthfully, candidly, that some of that behavior continued into his incarceration. But one of the things I did argue in the motion for expert funds is there is some research out there, and I presented an article that shows that kind of the natural maturation process that takes place can be stunted by incarceration. And that's why I suggested that an expert would be necessary in this particular case. Both.
Would that be helpful to you if the expert, obviously I don't know what the expert would say. I have no idea at all. I don't know what happens when the person is released. You know what I mean? But how would not having matured normally be helpful in terms of the risk here?
Well, I think that, again, this is kind of speculation. We would have to assume that the expert would be able to opine that it would, in fact, lower his risk. We don't know what that expert would say, but I think it would help inform the hearing examiner's decision one way or another.
And no affidavit of a proposed expert?
No, there was not. I
mean, when requesting funds, don't you have to submit something from the expert that you would have retained, or some type of document that outlines what he would say or she would say?
I would have to look at the specific regulation, Your Honor, but I will say that, it's not part of my practice generally in filing a motion for funds before the SORB to include an expert. I think there's some practical reasons that really prohibit getting.
Because they charge money.
Right.
Precisely. Do you routinely get the funds?
Pardon me?
Is it part of your practice is not to submit whatever when requesting funds? I'm asking, do you routinely get the funds?
I would probably say about 40% of the time I'm able to obtain funds and present an expert in cases. It's not unheard of. It's, more often than not you lose, but, with some frequency we do obtain funds, and I know some of my colleagues do as well. And so, again, the hearing examiner wrote in the classification decision that he was denying funds because the juvenile factors were accounted for in the regulations. And I would suggest that, that kind of just distorts the motion a little bit. I think we kind of fleshed out some more specific issues that the hearing examiner didn't really kind of want to address or didn't actually address. I do want to touch upon the burden of proof just a little bit here, because I think when you kind of overlay the mitigating factor of maturity and juvenile brain development, it kind of puts some of these risk factors into perspective. So there were no high-risk factors in Mr. Doe's case. There were 4 risk-elevating factors that related specifically to his offense. So these are static risk factors that will be applied, 50 years from now. If Mr. Doe goes for a reclassification, those 4 factors will always be part of his case. It will never.
When is he next eligible for a reclassification hearing?
So I think it would be eligible for reclassification in approximately 1 year. My memory is correct. The hearing took place in July of 2002, so he could potentially petition the court for reclassification 3 years later. But reclassification certainly isn't an automatic thing as well. The no decision.
2022.
Pardon me, yes, July of 2022, so July of 2025, give or take. Generally accurate, not precise. But you also have to consider that there is a threshold inquiry when moving for reclassification under the no case, the SJC case. So the offender does have to make a threshold showing of a change of circumstances before it goes to reclassification. It's generally a pretty low threshold, but it is something that needs to be proven, and classification isn't an automatic right. And then I would also say, when you look at those risk factors, like I said before, a lot of these are static risk factors. They were triggered by the facts of his offense. Certainly, they should be applied, but of course, they will be applied in perpetuity. So, no matter how much amount of time passes, those factors will be present. I would suggest that factor 11, which is violence unrelated to sexual assault, is on shaky factual ground. You've got a 2003 unarmed robbery, which I would suggest to the court is not an inherently violent offense. And that actually took place prior to the sex offense. And then the other case was a 2008 assault and battery on a corrections officer, which resulted in a dismissal. So we don't really know anything about the facts of those specific cases because the hearing examiner relied exclusively on the offender's Board of Probation report. So I would suggest that 11 certainly isn't supported by substantial evidence. And then finally, I would just point the court's attention to the risk mitigating factors here. The hearing examiner found 4 separate risk mitigating factors. And just one last thing I wanted to highlight is with respect to probation, factor 28, the adult male factor 28 says that risk mitigating factor can be discounted if there's evidence that they violated probation or community supervision in the past. That language does not appear as it relates to juvenile offenders.
Because this offender was on probation at the time he committed the offense, right?
He was, Your Honor.
I thought the hearing examiner had found something based on the fact that the Doe was not restrained by. I've got to see what it is here. The fact that community supervision didn't restrain Doe was considered. That is, at the time of the offense, was considered in the hearing examiner's decision. Am I wrong about that?
Yes, it was. That was, I believe, part of the factor 10, which was Doe's contact with the criminal justice system prior. So, probation is kind of, violations of probation would certainly be risk elevating, but being on probation, after the offense is considered risk mitigating.
Okay.
Nothing further. I'll rest on my brief. Thank you.
Your time has expired, so thank you. We will hear now from Attorney Shanai.
If it pleases the court, Your Honor, I'll be arguing for the board in this case, like every case. The interesting thing about this case is that if he were an adult when he committed his offense, I believe he would have been a 3. And the reason I say that is because he was a juvenile, the hearing examiner was not allowed to consider his behavior while incarcerated as a risk elevating factor, because factor 12 does not apply to juvenile offenders. So the hearing examiner in the decision doesn't apply factor 12. I think if you're an adult, and they applied factor 12, that would have been enough to put him at a level 3. So even in that sense, the board's regulations taking into account that he was a juvenile when he committed his sex offenses was beneficial to him in this case. I think the board's regulations do differentiate very well between, at least the research in 2016, between juveniles and adults. As for the brain maturation, we've had this argument recently that research doesn't specifically require or consider brain maturation as it applies to sex offending behavior. It applies really to criminal behavior in general.
Why shouldn't Doe have gotten those funds for an expert?
I think the issue in this case is that the board's regulations specifically considered the difference between juveniles and adults. And he's got to show that he has either a condition under Doe 151564 that is not considered by the board's regulations.
There are aspects of the difference that are not considered.
The aspects, I'm not sure there are aspects.
Let's just take an example that I was talking to your colleague about at the end, because this concerns me. The hearing examiner, I don't know how much weight this had, whatever, but at least says somewhere in the decision that because at the age of 16, Doe was not restrained by community supervision from committing a crime, at age 34, he won't be.
Well,
that seems like a pretty big leap.
Well,
and if someone asks for an expert to come in saying there are things about what happens in the maturation of a teenager over the next 20 years, that's not taken account of exactly in the regs.
Well, I think there's two levels to that, two answers to that question, because I think it's a multi-leveled question in a sense that, first of all, the expert would come in and testify. If he followed the studies that were introduced, he would basically testify that the maturation process for an individual who's treated as an adult and sent to state prison gets disrupted. And the 2002 article that was cited specifically says that that individual's risk is higher than a regular juvenile who's just adjudicated for a sex offense. So I don't see how an expert is going to come in and say his risk is lowered because his maturation process was disrupted, because the studies that are cited by plaintiff's brief specifically say that individuals like this individual actually have a higher risk of reoffense upon release. As to the probation, the idea is that if the individual's had problems with probation in the past, it may impact the weight of community supervision in the future. And on top of that, you look at, and even though the hearing examiner couldn't consider factor 12 as risk elevating, you can look at his behavior while incarcerated to say that he doesn't follow authority well. I mean, he doesn't, he breaks rules, he does what he wants.
We're not supposed to look, I thought you said, at his...
Not as a risk elevating factor, but when you're looking at whether or not he's going to follow future probations, I think you can look at that.
But I mean, maybe you disagree with this. I don't see what, we could go around to every 34-year-old and ask what they did when they were 16, and I don't think it would be a good predictor of what they're like at all. Well, I mean, in some cases it might be. It might be that's when their life of crime began, right? I mean, I have no idea. Or maybe they played piano all the time and now they're a concert pianist. I don't know. But their judgment and ability to control themselves and everything else is dramatically different between a 16-year-old and a 34-year-old. And to say you couldn't control yourself when you were 16 and here you are 34, so we're going to just increase the risk a little bit here. I mean, it seems...
Right.
Kind of silly to me.
At 65, I don't think you want to look back and see what I was doing at 16. I know
when you were
34,
when you were 34, you probably didn't want someone looking back and seeing what you did when you were 16 either.
This is true, but again, this individual hasn't shown any period of time from that 16-year-old time to now that he has.
Maybe that's adequate. I mean, to me, part of me thinks, well, let's hear what the expert has to say before guessing what the expert would say.
Well, I think I think if you're going to base your request of an expert on studies that specifically say that the risk is higher because of the individual circumstances, I think it's hard to be able to present a proffer that the hearing examiner is going to say something positive on behalf of the plaintiff, because the research is the research, and he's relying on that research as his proffer. If he had research that says his risk is actually reduced, then an expert would come in and testify to that, then I think that's a different proffer. That's not the proffer here. The proffer is basically, he's been in prison since he was 16. These studies say juveniles offend at a lower rate, and therefore an expert is needed. That's not sufficient, especially when the two of the studies they proffer say under his circumstances, his risk is actually higher. So I think under those circumstances, I think that the denial of the expert funds was fair.
Do you think that the hearing examiner should have counted the behavior under community supervision when he was 16 as relevant to likely behavior under community supervision at 34?
I do, in the sense that because of the fact that the whole idea is that it's showing that community supervision does not prevent the individual from committing crime.
Did not when he was 16.
I know, but I'm saying that this isn't a situation where he was 16, he committed the crime, and then 18 years later, he's committed no crimes in between or violated any probations in between. This is an individual who has shown a reckless disregard for rules.
I thought that couldn't come in.
It can't come in as factor 12 being a risk-elevating factor, but you don't look at the evidence in a vacuum. That evidence actually shows that, when you're looking at whether or not this individual would follow the rules of probation, I think it's fair game to look at his history.
Well, then you could write down, he's not operating properly under the intense supervision of a prison.
Right.
But that's not the same as saying he was 16 and didn't, right? I mean.
Right. Right. But again, the idea is you're looking at whether or not community supervision would prevent him from committing offenses in the future. And in this case, because of his track record, it's not a guarantee that community supervision is going to be able to keep him from committing future offenses. I think that's just really how that all comes down in the end.
And the articles that were offered suggest otherwise.
Right, and that's, again, and that's, the whole idea of expert witness funds is that they have a condition or something that shows that there would be a positive impact reducing his risk, and that an expert can educate the hearing examiner on that issue. That hasn't been presented in this case.
Was there an oral hearing on the motion or just a written submission and denial?
Well, there's a written submission and denial, but generally the hearing examiner then listens to the evidence at the hearing, and if determines that there is evidence that an expert should be used, they will issue the funds and order a second day of hearing.
So is it in some way renewed at the hearing, or that's just like it's sort of sitting there ongoing in some sense?
It's essentially ongoing, because the hearing examiner may hear evidence during the hearing that makes them rethink the expert witness fund situation. And like I had a case just right across the hall earlier where the hearing examiner 3 times requested the attorney during the hearing, after denying the motion, gave the attorney at least 3 opportunities to make the nexus, and they didn't do it. So, I mean, the hearing examiners are trying to...
In this case, was there anything like that?
No, but there was no evidence being presented that would change that, other than reliance on the studies that go against the proffer or hurt the actual, go against the motion itself. At least that's my reading of the transcript. But I've been wrong before, so. I think I've covered these issues fairly well in my brief. Unless there's other specific questions, I'd be more than ready to rely on that. I was thinking this morning, preparing for this case, I was thinking, when I retire, one of the things I'm going to miss the most, Judge Rubin, is our repartee over the years.
Well, I didn't ask you when you said that it would have been a 3, what percentage risk is a 3 and what percentage is a 2, but you know I'm bothered by the absence of an answer to that. I also have to say, I don't know if we think we're helping someone by giving them 2 oral arguments on the same day, but when I was a lawyer, that would have been no help at all. So,
Well, I did once have 3 in the same panel, so. And next month, I've got 4 with 4 different panels, so I think I'm going to see just about every judge in the court.
You're a busy man. Thank you both very much for your arguments. I see no further questions, and the case is submitted.
Thank you.
This concludes our sitting for today. I'd like to thank the court staff and the court officer for their, as always, excellent assistance, and we stand in recess.
What is now in recess?
Matthew, it's always a pleasure.
Nice to see you.
Good to see you. You got your pool open still? Or are you closing?
This is